Okay, it is 9:30 a.m. and we are going to start the meeting for the Texas Real Estate Inspector Committee, working group meeting. The roll call. Lee Warren.
Here.
I forget everybody's name.
Sean. Yeah, I got one.
Steve Reinhardt.
Stephen Reinhardt, yes.
Brad Phillips.
Here.
Doyle Williamson. Is Doyle here? Okay.
Not that I know of.
Who else am I missing? Matt Hart is not going to be here. Barbara Evans.
Here.
And I think that's everybody. Everybody else that's at the table, could you please introduce yourself? I'll start with you, Michael.
Mike Hamill.
Tony Slade, Government Affairs with Trek.
Paul Roebuck with Capria Internachi.
Kristen Warman, Trek Deputy General Counsel.
And are you guys the only representatives for associations? We don't have anybody for ASHE in the room?
No, we do not.
Okay.
And if I can just make it, if everyone would sign in, please, so we have a record who's here. And if you want to speak on any of the topics on the agenda, please fill out a form and give it to the chair so that she can call on you when the time comes.
And make sure you write the topic down. I have some that are blank. So it might be that you only want to talk about 2A or 2C or 1. And then anybody on the phone that can introduce themselves. I don't know.
Oh, yes. So I'm going to call roll for the people on the phone if you just say present. Commissioner Arriaga?
I am on.
Okay. Brenda Roebuck?
Present.
Okay. John Cahill? He shows that he's on, but is there anyone else on the phone other than those three and Dr. Evans? Okay, I think we're good.
That's it?
Yes, ma'am.
Okay, so agenda item number 2. Discussion and possible action regarding a proposed legislative fix for inspector consumer recovery issues as part of the agency's sunset recommendation, including potential amendments to Chapter 1102 Occupations Code to address the following, which is A, financial responsibility requirement for inspectors, B, the real estate inspection recovery fund, and C, contractual limitations of liability. Since this is a working group meeting, basically, and I'm confirming with Tony, it's similar to a workshop environment. I've never had anything called a working group, so I'm assuming it's similar to that, where it's an open discussion.
Yeah, I mean, you do agree with that, right? That's
Yes, that's
Okay.
correct.
Okay, so I just want to make sure with protocol, so that, so I guess we're going to start out, obviously, with item A, financial responsibility requirement for inspectors. And do we want to start with anything, Kristen, with you? Do you have any?
Well, I think in the materials at page 1 is the current financial responsibility requirement that is in the statute. And that is where we are today and probably where we should start. You may find that you don't want to necessarily limit the discussion to just 2A because some of the discussion on A may impact the discussion on B or C. So, I think you can start with the statute and then go from there.
Lee, do you have anything that you want to start with this?
Well, I just see that this meeting is our opportunity. A lot of where I think the confusion and the frustration started from a lot of people was they put this in the statute, what, in 07, I think is when this came in?
Initially, yes.
Okay. And it just says liability. It doesn't say professional, it doesn't say general. It says liability, and then apparently there was a opinion received from the AG that determined that it was E&O.
No.
That's
Okay.
not correct.
All right, so what was the actual clarification as to how that came about that it was E&O?
The Attorney General's opinion declined to interpret what type of insurance was required.
Okay.
And basically said that it was Trek's statute and the legislature had delegated to Trek the authority to enforce that statute. So it was up to Trek to determine which type of insurance was required. So after consultation with the Department of Insurance, TREC determined through the rule that it was professional responsibility as opposed to general liability insurance.
Did anybody actually talk to the legislator that actually created the bill to see what his intent was?
There is nothing in the legislative history. We consulted that, but we did not consult with one legislator, because typically when you look at statutory interpretation questions, it doesn't matter what the intent of that one legislator is when you challenge the interpretation, because it's the will of the legislature.
I understand that from the AG, but if the AG sent it back to us for us to interpret, more than likely whoever started this whole ball rolling had a specific intent as to what that was supposed to be. It seemed logical that that person would have been consulted to say, hey, what was your thought process? Was it just general liability, so if an inspector breaks something, that's fine? Or is it to go E&O and to push us to an insurance requirement that not even agents or brokers have to do? So that's,
Well,
so I guess my answer is no, nobody ever went back to that legislator.
To my knowledge,
started.
no, we did
Okay.
not go back to the specific legislator.
Okay.
But typically in an occupational setting, when you're talking about insurance and financial responsibility, you're talking about E&O insurance, not a general liability policy. While
That's what
general,
most businesses carry is general liability
Yeah,
policies.
that's
I
true.
don't know if I agree with that. But
Well,
Okay.
I'm not saying that it's not a general business practice to carry both, but typically when you're looking about the need to follow the practices, the prohibited practices, or protection against practices that are prohibited in the statute, that would be an E&O responsibility as opposed to a general liability responsibility.
I don't know. I don't really see it that way. I see the recovery fund is really covering a lot of that, and the lack of use of that recovery fund should have spoke volumes to a lot of that. But I think, I don't know, stepping back, I mean, I guess where we're at here is we've, for 10 years, over 10 plus years, we've been kind of going back and forth about this whole insurance thing, and now you had brought up the possibility of an issue with the current, most of the policies that are in there with the defense within limits and that type of stuff, and possible issues to get right into. But in the end, as a committee and even as a commission, there wasn't a whole lot we could do because we have to, it starts with the statute. So we have to, if there's a change to be made, we have to start with the statute, which is really what I saw kind of the focus of this. If we're going to recommend a specific change to the statute, we do that here, supply it to the Sunset Commission, which makes it part of the legislature to clear everything up. Am I correct? And that's basically our main purpose here, is if there's going to be changes that need to be made to the statute to clear all these questions up, that's what this is for. Whether it be to leave it the way it is, which I don't think we're going to have to clean it up some way, to specify E&O or professional in the statute itself, or to get rid of the insurance requirement altogether and just go back to having a recovery fund, or keeping this, bumping the limits, getting rid of the recovery fund. But that's where we're at, correct?
Yes, the purpose of the group is to gather input from the stakeholders so that we can make recommendations to the commission, and then the commission can make recommendations to the Sunset Commission as we go through the sunset process that will hopefully be adopted by the legislature.
I don't think raising the limits, I haven't seen any documentation from any insurance company that says raising the limits is going to affect anything. The amount of policies that have come through that have even come close to that amount, even with defense costs involved in that, less than 0.1% or something like that of the numbers that we received before. So that just, to raise the limit seems just too much of an unnecessary burden on inspectors to endure that cost. If an inspector wants to have a higher limit, fine, no problem. That's a business decision on their part, but to require that, I think is and the defense within limits, that's been talked about so much, but that policy doesn't exist, and I think that's completely counterproductive to everybody involved to get the defense within limits.
You mean defense
wiped out.
outside?
Yeah.
Defense outside. I wanted to start with the two associations that did come so that we can hear, we've received documentation from each of you, but I still would like to. So we're going to start with Michael as far as you're representing Terry. And I'm assuming that based on any polls or anything you guys have done, what you're speaking about is from your membership, which is how many?
I don't know, what are we at, 250?
Okay, that what you're going to speak about or speak on is on behalf of that membership and whoever else.
Absolutely. And we're pretty much along the same lines as Lee in regards to the insurance and staying at the current limits at the most and doing away with the recovery fund.
Okay, but E&O, GNL, E&O and GNL, where do you guys?
We're leaning more towards GNL
Yeah.
because that's what your traditional business model is going to function off of.
But, and so 100,000,
100,000. Yeah.
general
and again,
liability only.
If an individual or his or her particular business wants to go above the 100,000, more power to them, but they shouldn't be required to carry more than 100,000.
No recovery.
So no recovery fund?
It's not used.
Okay. And Mr. Roebuck, you're representing,
Tapria, Internachi, a little over 1,500 members in the state between the two associations. Our position and what our membership have told us is that the E&O requirement is what we are opposed to. We feel that the requirement was should not have been a requirement for inspectors. We don't feel that that's a level playing field with the agents and inspectors. It's not that we're opposed to carrying E&O, but we do feel that's a business decision that each member can make on their own. As far as raising that to a higher fee, that's pointless. I mean, there's no need for that. As the references that we provided from our attorneys said, there's not any claim that they can show that would come anywhere near that $100,000 for a loss from work that an inspector done. General liability would probably be more in line with what this thing should have been interpreted as to start with, to protect damage to the property. But even the $100,000 on that, just think about it for a minute. What kind of damage would we have to do to a house other than burn it down to equal $100,000? I mean, yeah, some houses are expensive, but most of the time we're not going to damage property like that. I mean, if you just took a survey of this room of people here, it probably never happened that we had that kind of a loss, something we screwed up with. So I mean, it really gets to be a question: should we even have requirements for insurance or not? And our membership has said no. That's been the one thing they've hated from the time it first was pushed upon us, which we know the history how it got pushed at the midnight hour with some representative that pushed the thing, or lobbyist actually. And it probably never should have occurred. Now's our chance to go back and say, hey, look, we have a recovery fund in place. And the recovery fund doesn't have a lot of claims, and there's reasons for that. It's the way it's set. But that's fine. Are we going to step aside and do something that's not a level playing field for all the real estate licensees that's through TREC? I mean, do realtors have to have the required insurance? Do they have a recovery fund? We know the answers to those. They have a recovery fund. Theirs is used a lot more than ours, but proportionately they have a whole lot more licensees than what inspectors do. I mean, we're a small number. So, our position is keep the E&O. It's 12.5. We know that if you get a claim, that
Keep the recovery fund?
Keep the recovery fund, sir. We know that they have to repay that, but at the same time, it's not that big of an amount versus what their deductibles are with E&O and everything else that would come along. So, our stance is, leave the recovery fund as it is. Eliminate the insurance requirements.
So by leaving the recovery fund as it is, that means that you could get a one-time payout of $12,500, am I right, Tony?
Correct.
Which means that your inspector that might have to dip into the recovery fund, let's say that's the maximum amount they can take, but this is for conversation's sake, that they had a $20,000 judgment against them for damages. Let's say they left a tub running on the upper floor and it ran through for a weekend while somebody was gone, or it was vacant, and now the house has tons of damage, because water is usually the worst thing, in my opinion. Then your inspector now has to go to the recovery fund for $12,500. He can't practice, he can't do his job anymore because his license now is inactive, or and he also has to come up with the remainder of the $20,000. I'm wondering how that protects the inspector as far as
Well,
as far as being able to earn the money to pay back the $12,500 and the
Very good
$20,000.
point. But, you know, again, the insurance is a business decision. Did the inspector decide not to carry E&O or general liability? And if they did that, then that's, you know, it falls back on their lot.
Right.
But, I mean, do we set it for one?
The judgment for the consumer. How will he get, or she, get their remainder of their money? What if this particular inspector is only in their first, second, third year? They can't carry, or they won't, they're not carrying any insurance. They haven't made that business decision yet. Then our task and this is just for conversation, our task as an inspector and as this committee, which is to look out also for consumers, you know, or mostly that's our task. That means that we're making a decision that could possibly leave a consumer who had a judgment unprotected, because all they can get is $12,500, and that person maybe doesn't have the rest.
But wouldn't the courts take care of that at that stage?
I don't know, but I feel like as a commission, as a committee, that we have to think about those things. You know, I'm not disagreeing, I'm just throwing out an argument.
I'd kind of like to walk through
Sure.
the process for a recovery fund payment. Before it ever gets to a payment, that inspector has been drug into court, and he's had legal costs already. If he's smart, he's had legal costs. I don't know what you pay for attorneys, but I know what it costs me when I have to bring one in. And he could spend $3,000 to $5,000 before he ever gets there, easily. And so he's already spent $3,000 to $5,000 out of his pocket. He's got a judgment against him now. The commission then has to make a payment after they go through their due process, and that's maximum of $12,500 that the consumer could receive, less their attorney fees, which are included in that $12,500. And let's just say it's a $10,000 judgment and they've got $5,000 worth of legal fees. They're not only harmed, but so is the inspector. The recovery fund, as it stands, is not functionally consumer friendly. It's not inspector friendly from my perspective. It doesn't protect the inspector and it doesn't protect the consumer. It's something that we've had in place for I don't know how many years, I guess. I don't know, was that originally inception when we started this thing?
You know, I should know that.
I don't know the answer to that. I know it's been there ever since I've been in for 30 years. And we paid $100 a pop going into it when I got started. And the surplus has gone to the general fund after over $600,000, I believe, subsequently. And there's been minimal payouts. And part of the reason there's been minimal payouts, in my opinion, is because of the difficulty to get to the recovery fund for the consumer. I think it's probably, in my personal opinion, the recovery fund should go away, and we should maintain the $100,000 worth of liability with defense within limits, which protects the consumer and inspector both. It just benefits everybody. Whether you want to call it E&O or general liability, makes me no difference. It just needs to have defense within limits, as most policies are written. And I think if you do research and look through the whole thing, you're going to find that's better for everybody involved. I rest.
Can we get that last part recorded?
Yes.
That doesn't mean I'm through for today.
Mr. Reinhardt, do you have any?
No, Penny, no. Yeah, it comes down to, I've got kind of three choices in there, probably more as a priority. The fund, I'm not a real fan of the fund for some of the obvious reasons. It's hard to get into, it doesn't have, the amount was probably fine 30 years ago, but it's never been adjusted like most things. But the biggest detriment on our side is if it gets tapped, our license is basically suspended until it's paid back, which means
Which means most inspectors would do everything they could to go around ever having to hit that recovery.
but I mean,
they
that's,
would.
it's kind of unreasonable. I couldn't find any other industry where you're kept from working until you paid it back. You had to do something else. It's kind of, it's an unusual, it's a motivation factor. It's motivation not to ever have a problem. But it doesn't seem like a viable way to protect anyone. You know, it's like Brad said, it's not enough to do a whole lot for the consumer, and it's a danger to our livelihood if it gets tapped. Whether it's defined as general liability or E&O probably doesn't matter to most inspectors. They're probably going to have both. I myself have the opinion, looking at all the associated data, that it was probably meant to be general liability. If it was redesignated as general liability, I would still have both, but at least it's an option. It's a business decision. The general liability seems to make a lot of sense. The first choice would probably be define it as general liability and eliminate the fund. There's no benefit. I mean, it's not like we're going to get the money back. I think if it's eliminated, it probably all goes to the general fund.
No, that'd be
There, when it was
refund?
proposed initially, and I can't speak for what the legislature would decide, but when it was proposed initially in 2013 to remove the recovery fund, there's a process in place by which every inspector that paid into it would get their, I believe, their initial money back.
Okay.
But that was a proposal that, again, I can't speak for what the legislature would do. But no, there was opposition to keeping to doing that, so it was removed.
Yes.
So.
I mean, whether or not we get a piece of it back, my preference would probably be to remove it only because it's such a liability to the inspector if it gets used. That's my main reason there. I like the general liability as a definition. Again, I would probably keep the E&O. If it was defined as E&O, then I would say defense within limits, like it's been working for the last 7 years. I might also recommend that it's 100,000 and maybe aggregate would be like 300,000, which would be a reasonable thing, and which some have suggested it might even bring the policy into a more defined policy from the carrier side that would make it less unique and maybe a little more cost effective, instead of having to write an unusual 100,000, which seems kind of unreasonable with the insurance carriers that I've talked to.
Right.
And those are kind of my choices. Dropping all the insurance and keeping the fund, probably the last alternative.
Okay. Okay, Sean?
Yeah, I mean, I'm pretty much in line with everybody else. I looked around a lot and talked to my insurance agent last week, and I mean, I can't find anybody in the state that's requiring E&O, TDA, if you're going to be a mold inspector, remediation, HVAC, plumbers, engineers, nobody's requiring E&O. The only ones I could find for G&L was the plumbers. If you're going to do mold remediation inspection, you got a G&L and then TDA. Nobody had lower limits like we do, but I mean, I think the E&O is way out from what we should be requiring. And the recovery fund, I think, like everyone said, just makes it almost impossible for you to I mean, if the goal is to protect the consumer and we want the inspector to make right what he did wrong, we've got to let him be able to work and make a living. So I don't see how the consumer benefits for having an inspector that's just going to go bankrupt and we're not going to get any money out of it.
Kristen put together insurance requirements for inspectors by state. Is that something you can?
And I didn't know if you wanted, I didn't know if you wanted to ask Dr. Evans.
Oh,
as
I'm
well.
sorry.
That's okay, I just wanted to make sure we.
Dr. Evans?
Yes, I'm in line with it and with the definition of general liability included like Steve asked.
Okay. Okay, so, thank you. So Kristen put together a chart that has all the states that do require insurance, and the summary of it, there are 34 states that regulate inspectors. 23 of them require some form of insurance. 11 do not require any type of insurance. I saw some with bonds, but the bonds are like super low, like 5,000.
This state list is just the list of the states that actually regulate inspectors.
Right, correct.
Correct.
So this is on par with Texas. And then we have the 23, 9 are both the E&O and general liability, 5 are only E&O, 9 are only general liability coverage. And then it looks like the majority require limits of $200,000 or more. And so we're in obviously the 6 that have limits of less than 200,000. I don't know if there's a way to even understand, the 200,000 that's more, or why we have considerably less. Do you know if Kristen, what their reasoning behind that you could tell behind how they set the limits?
Well, some of our research revealed that states do different things whenever they're deciding the limits. For example, I believe that Florida looked at the average cost of a home or sales price of a home, and so that's what they set their insurance limits to be consistent with. As for the other states, I'm not sure if we identified any specific rationale.
Right.
My guess would be if you looked at other professional occupations in those states, for those that required some type of financial responsibility, the limits would be similar in those states. We don't have the dates of enactment of each of these requirements, so it could be that other states have simply updated theirs more frequently than Texas has. I think one of the commenters mentioned that, at least from the recovery fund perspective, the last time those limits were looked at was several years ago. So it's not something that states typically look at every session or every time the legislature convenes, and generally is dictated by instances that happen and occur in each state.
I called and talked to insurance providers in some of these surrounding states, and all of them that do require insurance allow defense within limits in their policies.
Which is a standard
Which is a
policy.
standard policy.
Yeah, okay.
So none of them that I talked to have defense outside limits.
Okay. Okay, so where we are right now is I have a lot of people that would like to comment from our group. So I'm just going to go person by person so everybody can get their comments. Sure.
Kristen, can you break down, just so everybody's kind of on the same page, because we all keep talking about it. I want to make sure we have a clear understanding. What is covered with a general liability versus what's covered with an E&O? What are the main differences?
Sure. E&O coverage it stands for errors and omissions. So typically that is going to cover things that you miss in the inspection, defects that you fail to identify in your inspection reports. And in contrast, general liability will cover your own acts of negligence or,
Damage.
that happens. For example, recently, the inspector committee has heard about several claims regarding inspectors who have performed the hydrostatic testing even though they weren't licensed as a plumber. If a house is damaged in that type of testing, then a GL policy would kick in, but it's not likely that an E&O policy would kick in. What staff's research has revealed with respect to talking with insurance companies and insurance agents is that the E&O policies that inspectors have, that typically covers your entire premium, obviously, because that's the statutory requirement. But to a person, most of the agencies said inspectors can add a GL policy for minimal cost, usually $50 to $100, that would provide the same coverage of $100,000 in GL or general liability.
I just want to make sure everybody's on the same page, so we all know, because we're going to be talking about GL versus E&O, and I just want to make sure everybody knows what covers what, because we're talking long term here.
So there is a difference, and there are some things that would be covered under one versus not under the other.
Damage during an inspection will be covered under your general liability as opposed to an omission or an error.
And so if,
Well, and what-
so if a
Fall through a
if an-
ceiling, for example.
Okay, yeah.
Leave water on,
Overflow
flood a
tile.
house, anything like that.
That's why these
will cover it.
builders are requiring these large policies,
Because they know what
specifically
you're doing
general
when you're
liability
doing the house.
policies, not E&O.
Right.
So if an inspector was negligent about an item on the report, that the standards of practice, that they didn't do or omitted or missed, and it was something that a consumer wanted some kind of repayment for because they bought the house and said, I never would have bought the house had I known this.
Mm-hmm.
Would general liability cover that? If there was no E&O and we just had general liability, how does that consumer get any kind of a repayment or?
Sue you.
Well, they would have to sue the inspector. They would typically bring claims for negligence, DTPA actions, and the like, violations of their duties under TREC. And the court would look at the claims and would look at the damages that were at issue in the case and would decide whether or not the inspector was liable for those damages. Depending on that judgment, the recovery fund may respond to pay. Typically, the recovery fund pays for actual damages. So that is, in essence, your GL policy for inspectors. That's what the recovery fund responds to. But the recovery fund also responds to negligence, omissions. So it would cover both.
Mr. Oldmixon, do you want to introduce yourself so we have you on the?
Oh, certainly. Doug Oldmixon, I'm the Executive Director of the Real Estate Commission.
Well, thank you for joining us.
Oh, you're welcome.
So if we have, and this is for you, Mr. Roebuck, if we have general liability only of, let's say, 100,000 defense within limits, would you want to keep the recovery fund in place?
You know, I'd have to poll our members to give you a definite answer on that, but I don't know.
It sounds like we would still need the recovery fund if we only had general liability. Otherwise, the consumer that is suing and has the judgment goes after you personally if you don't have any other insurance. Am I right?
Actually, it seems backwards.
If general liability covers negligence, why would it not cover something that we missed?
It doesn't cover.
It doesn't cover negligence?
Right,
It
so
doesn't-
if we keep an E&O policy, we would have to keep a recovery fund because it covers.
Oh, okay, but if we keep only general
Yeah.
liability, we don't need the recovery fund? Okay, I had it back.
Recovery fund is basically a general liability, a smaller general
Smaller
liability.
general liability, but she says it also covers omissions, errors and omissions, so she just said that
It can respond
to that.
and
Okay.
pay based on negligence
Right.
of the inspector.
What?
I'm just thinking out loud.
Wouldn't the negligence like that on GNO, wouldn't that be something like she was talking about, a tub running over causing damage? Wouldn't that fall under negligence for the inspector?
For a general, not a.
That's what I'm talking about, general.
It could go errors and
I mean,
omissions.
it could also go under errors and omissions.
Could go either way.
It could go either way. I mean, that's what the insurance companies have said. I mean, because when talking to the various insurance companies that write the type of insurance, the E&O insurance in Texas, we've given them different scenarios based on the types of claims we've seen, some of which the committee has evaluated under the enforcement reports that you see every meeting, some of which we see in the recovery fund claims that we have received, and some of them we see on the real estate side in recovery fund claims. So we want to know, well, what happens, for instance, if you're inspecting a house and you don't find any visible evidence of a problem in the plumbing, you don't find a water leak anywhere, you don't find any evidence of anything going on, so you don't put anything in your report. Well, your report is good like that day that you're inspecting the house. So what happens if there is a latent leak that is undetectable when you're there that day? Then who responds and what covers them in those instances?
So you're, if I understand what you just stated, it sounds like the inspector would still be responsible for something he didn't see that may have been going on that day?
But they'll try to sue them for it.
That's what I'm getting at, is that even if you don't see it and you don't report it, you may still be subjected to a lawsuit, to a claim against your insurance policy, and to all of these other types of recovery that a consumer may seek when that issue comes to light.
I mean, every insurance company I talk to, the vast majority of claims that come through are, they're ridiculous.
Sure.
They're looking for somebody to pay out. They feel they've been wrong. They're looking for somebody. They're looking for everybody with a policy that they think they can get some money out of. Which is why when this whole defense without limits thing came up, no, because that's so much of what is part of that policy
Sure.
is defending. Insurance companies will say, here's your report. The first thing they're going to do when you have a claim is give me the report for that property. They want to know exactly what you said, whether you checked every box or put every little thing in there. And if you did, they'll pay for that as part of your policy to defend that, so they don't have to pay it out. But we start playing with that little caveat, and we're going to run into big problems.
I think your errors and omissions covers most of that. I think that if you choose to have general liability, that's going to cover if you break a Chinese base or something else in the property while you're there. That's what your general liability is for.
Yeah.
Any negligence or omission is covered by E&O. General liability is just what it is, general liability.
So the only way that a consumer could recover anything from an omission, and they purchased a house or without the full information that they felt they should have been included in the report, they would have to sue.
Just like every other.
Well, they'd have to,
But they would have to sue
File
us
a claim
anyway to
against
be
your
able to get
insurance.
anything from the recovery
Yeah,
fund or to
or
be
the
able to get
insurance.
anything from our insurance.
Yeah.
You can't do the recovery fund until you've already gone through the process and have a judgment.
Right, and the insurance claim also has to have some sort of formal
all they've
claim.
got, well, just a claim though. They've just filed a
But it's
claim,
not a lawsuit.
not
Okay.
necessarily a
I
lawsuit.
never.
I think we need to make a strong distinction though. What E&O does protects the consumer for errors and omissions, and general liability
Is it
protects
protecting
them
us, protecting
of the
inspectors.
property for anything you might damage while you're there.
Right,
And there is a fine line on some of that between the two.
right. Okay. So I'm going to start with the public meeting comments. Randall Ryden of Capria.
Molly, you want to take my time?
I'll give it to Mike. Mike's been waiting.
He's not now. Jim Adams.
I'll,
Okay, so how will I know when you guys decide you want to do? Okay, so somebody behind will have to tell me.
I'll let you know. I'll get Lee's attention.
Scott Reagan, same way?
No,
Regan, sorry.
Regan.
Okay.
I want to give you all some information about insurance. My company, like I stated last time, we do air conditioning, pest control, home inspections, energy audits, and all kinds of stuff. My air conditioning insurance, $500K with 300 aggregate. That's the big word we're all missing. It's $500 a year. My pest control is $650, covers $600,000 with 300 aggregate. My inspection, I carry $500,000 in policy. I pay $950. We have 5 inspectors. It covers an additional $200, $300 a year based off of what they actually did. Where I'm getting at it says right there. It says E&O is what you're looking at for insurance. Well, you stated Arkansas has a $100,000 general liability with no aggregate. If you look at our form that we fill out as inspectors from our insurance company, it's a $100,000 limited and a $100,000 aggregate. There's where the problem is. Are we general or are we E&O? And if you look at what policies are written and how it's written, you need to go back to just being an E&O policy and get rid of the recovery fund. But actually, you need to look at the insurance for the state of other organizations and how they're written too. Because everybody's missing the word aggregate is what's setting the whole insurance to be at a higher price for inspectors compared to all the other trades. That's what I want to say.
Thank you.
So, real quick, so you'd rather see E&O get rid of the recovery fund, correct?
Yes.
Under what minimum limits are you talking for individual and for aggregate?
No aggregate.
Okay.
Aggregate makes you have to go to a G&O policy. Because E&O is general liability of the performance, not the aggregate of each occurrence. Each occurrence falls under general liability. So right now, as a good insurance company, policy, and inspectors, most of us carry both for the protection of us as an individual. But if you're going to require one, it has to be one or the other. You can't mix and match them, and that's why the insurance companies are saying they've had to make up a policy. Since the beginning, this policy is not even recognized in the insurance field. So when you go to get sued, the first thing they do is they go after which one do you have the highest of.
Yeah.
That's exactly what they lose, and that's the truth. Coming from every attorney I've talked to is, okay, what is your general liability and what's your E&O? Because the bigger the one, we're starting with that one, and then we'll go to the next one, and then we'll go to the next one, and then we'll go to your personal.
Go to who has the deepest pockets.
Exactly.
Yep. Yes, sir.
I'm David Sweet, and I have the distinction of being a 30-year insurance agent as well as a home inspector. So some of your definitions are not quite right. The aggregate is if you have multiple professional liability, and I spent most of my career in professional liability on the medical side.
Can we whoever's eating on the phone?
So the aggregate only applies if you have multiple claims in the same year.
Right.
It has nothing to do with your general liability versus your professional liability. Okay? So just to get that perfectly clear. And your comment about the lawyers can go after whichever has the biggest liability. Typically, your E&O and your GL are going to be on the same policy because the GL is a rider and it's inexpensive. The insurance company is going to decide which policy they pay them. That has nothing to do with the plaintiff's attorney. Okay, just to get everything clear.
So when we're talking about a policy that has 100,000, 300,000.
So if you have one event, it will pay up to $100,000. If you have 10 events, it will pay up to $300,000.
So 300,000 is our aggregate.
Is the
And
aggregate.
100,000 is per instance.
Per occurrence.
Per occurrence. Okay. Okay. Thank you very much. Okay, Jim time. Is that right?
I'm going to abstain right now. I'm still gleaning information on this, going to limited liability and those things.
Okay, thank you. Bruce McCrary,
I'm going to yield my time to Paul. Thank you.
okay. William Riley,
Well, I'm here to speak on the limitation on liability.
okay, so we're not
Right.
to you yet. Michael Moran,
Good morning, ladies and gentlemen. Like you said, my name is Michael Moran. Been an inspector now going on like 24 years or so. Prior to that, I was with the federal government, another 21 years. I'm basically here sitting, I was here last month, I was a couple of months before that, and a few years before that, right, Doug? So I've seen a lot of these meetings taking place and so on, and there's like a little too much going on that doesn't make it clear for everybody, okay? If we are an organization of inspectors, then we are professionals, right? Okay? Then we should stick to whatever it is that we're supposed to do, and that's inspecting homes. That's what our license calls for. It doesn't call for inspecting warehouses, commercial buildings, and so on, right? So what are we doing? We're getting into all these areas that basically have nothing to do with what our license is called for by the state. I do understand that we do have to have a responsibility to protect the public. Well, geez, the public is the one who's paying us. Of course we want to protect them. But yet we're saying, well, suppose this happens, suppose that happens, suppose this happens. Suppose anything else happens. Now, we look at this list of all the states in the United States to try and decide what's E&O. Texas has one of the lowest priced of homes in the United States. Go to California, you think you're gonna find a $100,000 home to inspect? Of course not. But then you're gonna tell me that I need $250,000 insurance? Right? So we're getting, in my opinion, of course, we're getting kind of out of hand in all these different things that we want to do regarding insurance. We are professionals, we have a professional company. Each individual is going to look out to protect their company. I've done that for 24 years. Brad, didn't you say, 30 years? Okay, and I'm pretty sure if I look at the average, it's going to be more than 10. We're going to look forward to cover our company, cover ourselves as inspectors, and at the same time perform what our license says that we're supposed to be able to do. And that's why we have to take E&O, right? And that's why we have to take continuing education. And every year we pay, and every year we pay. From what I can see here, we're getting completely out of hand, and we're just asking to do this, want to do this, should this be this? These two gentlemen, they disagree with their own insurance, and I'm pretty sure they're both paying. Okay? So, the committee, please, let's get into one thing. Everything starts with what the homeowner. Okay, the homeowner, he's got his own insurance, right? If he allows me to go into his home, it's because he's already signed an agreement with a listing agent. Okay, if I get hurt inside that home, hello, inspectors committee, can I claim help? No. Hello, homeowners, can I claim? Thank you. Okay, but it all started there. So what is it that we're getting around out of all these different places, all these different comments? No, it's completely out of hand. That's my comment on A. On B and C, I'll come back later.
Yes, sir. Thank you very much. Mike Cothran.
I got my bottle, Mike.
I'm getting old.
Time's up.
Remember, Mike, there's a 2-minute limit.
Maybe, well, it's 3 downstairs, and what's the deal? Actually, with your permission, Diana, we've had some discourse right here. I'd like to make a couple of comments on 2 of the issues that came floating by, and one was the recovery fund. In its wisdom, Trek has over the years, and there hasn't been very many uses of it, you're right. They have, indeed, the law says that you lose your license until you repay the fund, but most times Trek in their Omnipotence has realized that this is really onerous, and they have made scheduled payments and put the guy on probation. They realize if he doesn't have a living, he can't repay the fund. So that's number one on that. Number two is, don't frown, Phillips. That's number two is, that as we learned at the last commissioners meeting, those of you who listened in or were present, Diane, you probably heard this, that it is possible to get a civil litigation judgment. That's what you have to go to the recovery fund. So you can be made whole by the civil courts and go after a little extra from the recovery fund. This happened and was sanctioned by TREC at the last commissioners meeting.
Wait, what do you mean go after a little extra from the recovery fund?
Whatever the judgment was for, he was able, his client who won the civil litigation was able to go for, and it was approved, as I recall.
Right, but it's not extra. I mean, it's you're getting back. It's basically restitution for what you actually have.
The client was made whole by civil award. Then they found out, or somehow they realized that there was extra that they could go for in the recovery fund. So they were coming after that as well. And the man made this point in front of the commissioners, and it was approved at any rate. Look at the tapes, Lee. I'm sorry. That's just the way it was.
If I might clarify the way the recovery fund works so that we can address this issue before it gets out of hand. Yes, you're required to go to court and get a judgment before you can apply for a payment from the recovery fund.
Correct.
The payment from the recovery fund merely goes to satisfy a portion of that judgment.
Correct.
So it's not over and above what the judgment is, and in many times, in most instances, it's much less than the judgment that the court awards. So then what happens is the plaintiff who got the judgment can go after the inspector or the respondent, be it a real estate agent, a broker, or an inspector, for their personal assets, their home, their car, anything that they may have over and above those assets that are specifically excluded by statute. So if you have other property and you sell that property, that sale can be attached and used to satisfy that judgment.
Because I was particularly concerned about this when I heard it, I did read through all the materials and even the enforcement actions from TREC when they judged whether this was real, and it did not bring that up. It said that they were made whole in civil courts and then came after what they could in the recovery fund based on a judgment out of the civil courts. But it was the same suit. The point is, double jeopardy is potential here. And with the loss of license.
No, there's no, that's simply not true.
Right.
There's no double jeopardy. Never.
If you have a $20,000 judgment and you get $12,500 from the recovery fund, you can only go back after the respondent for the other $7,500.
That's correct.
You can't go after him for another $20.
Okay.
You can't do that.
Take a look at the materials, Lee. I just read what I read. But I will go with what you're saying on that. Okay. Finally, well, you know what? I'll hold on that. The second point I wanted to speak to from the discussions earlier was on the AG's opinion. And not everybody in the room was around in 2007, but maybe half the room or so was around in 2007 when this came down the pike. And as Paul said, it was a 1130 submission to the law, and it just happened to be the budget law that the governor was absolutely going to sign. But you'll remember that Governor Perry did say this was an onerous action and needs to be revisited. However, after that, because it was unclear whether this was a GL or a professional liability statute requirement, TREC did go to the AG, and I obviously have read that several times too, and I just got a little different take on it. The AG at one point said we can't tell if it's which kind of liability insurance it is. And my question is, if the AG can't tell, I don't know that TREC could tell and could make that decision either. So just a couple of points on that. Now, that takes care of the discussion so far. You are today deliberating as a working group the liability of a licensee of TREC. And as a licensee,
of Trek, and as a business owner, everyone in the room who's not working for the state today has a civil action liability that they, you know, anybody can sue anybody. That's the way it is. And we're all under that liability, no question. That's why E&O insurance was invented. It's a business decision that the business owner should take and make on his own. I made it before this requirement, and I'll have it after this requirement goes away someday if that's possible. The point is, it's a business decision. To mandate it by state is somewhat like, you know, I know this would never happen, but mandating that a private health insurance product be purchased. Otherwise, you're outside the law. The second liability is mandated E&O, which I think I've already said to that, and one of the proposals that's being danced around is to raise it from $100,000 to $300,000. I appreciated the comments that, hey, 100 grand is plenty if we need it at all, but my contention is this should not be a statute. The third liability that we're under is, of course, the recovery fund. We've already discussed that to some extent, but to remove it, obviously, as Tapria stated in 2013, and the governor then agreed with, this is a consumer benefit. Even if it's never used, it's still a consumer benefit. And so if we say that we're working for the consumer here, and all of us do, whether we're in private or here at an inspector committee or work for the state, that's a valid point. And I don't know that it should necessarily go away, especially with what I've told you. The fourth is in the last 10 years, there's been something called an enforcement matrix or a penalty matrix that has cropped up here, where this liability is also in effect under this, where for perhaps as much as 10 times the value of a given inspection, a subjective and overburdening enforcement action can be relegated on the licensee. I see that as fair, unjust, and onerous. And then back to my original point that we had some argue with before, but many of those four can be generated as a liability jeopardy matrix from one single complaint. One single complaint can generate several moneyed actions, several liabilities from those. So that's where we are today. New coming up that's floating around is, of course, moving the E&O from 100,000 to 300,000. The defense outside of coverage limits, which Lee spoke to a little bit ago. Limiting contractual liabilities. I think last time we met,
we're not there yet.
Let's hold off on the contractual liability.
So
I'm just telling you where we're at. This all
are
came
you
from the
speaking for Tapria, or are
self-evaluation.
you speaking for just yourself? Because I'm just trying to make sure that you're not going to be repeat yourself.
Okay.
So we can let everybody else speak also. So I'm just making sure that
Okay.
I understand.
So dissolution then is the fourth one of the recovery fund, which we've already covered. Trek has also put this in their self-evaluation that goes to the Sunset Committee, and their hope that all of these things can be put into legislation from a recommendation from the Sunset Committee and be handled as by statute rather than by decision or any other way. I remind you, as you deliberate over these issues, however the outcome may be, that inspectors are regulated by a commission where they have no voice. And I know we've got an inspectors committee, but you know, and I've spoken to most of you around this table, you have said that you do not represent, let me finish, lady. You do not represent the inspectors here, you represent the consumers. That's probably the way it should be. The point of no voice is still there. Second, last year, the Enforcement Division said on their paperwork that I read from the end of the year results was there was 80 complaints against inspectors. That's a lot of complaints. But when you consider there's, as John Cahill calculated, there's no true way to find out, but there's probably 200,000 inspections done in Texas every year. That's a very, very minimal amount. And then from the E&O providers, we have gleaned that in the same one that Kristen took her numbers from on a previous inspector committee profile that she generated, 23 over the last 8 years of those complaints have been regarding SOP. By far the vast majority is, as Lee said, frivolous, absolutely frivolous.
Can I ask you a quick question? I apologize for interrupting, but I just want to ask a quick question.
Sure.
You're going over a lot of things history-wise that either we've already talked about at this meeting or in previous meetings. What is your position or your association's position on, we've all kind of covered, this is what we want to see. You know, as far as whether we want to see the recovery fund stay or we want to see it go. We want to see 100,000, we want to see aggregate 300,000, whatever the case may be. We understand the history of it, we've all seen the history of it. What is your actual position and where you think what the end result of this meeting should be?
Of course. The reason that I did this would be valid, because that's really your question, why am I going over all this history, is because we have danced around 3 different issues here this morning. At the last inspector meeting and at the previous inspector meeting, it gets very convoluted, and as Mike said, it's very confused. As you deliberate, I want to kind of make sure that you've got all of these issues in mind, and some of the reactions that can come because of the decisions you make. And just to finalize, in your packet today, there's a letter from Dean Lazzotti. He's McAllen, Texas. He's an inspector and a broker, just like you are, Lee. And he says, if any more undue and unreasonable requirements are pushed onto inspectors, I believe the consumers will be left without the protection of third-party inspectors, as inspectors will be forced out of business.
I don't agree with
The
that.
liabilities, but you got to be open, Lee. Okay.
Oh, no,
You shake your hand.
I'm open, but I
You
think
know,
that's a
listen,
drastic
I could not-
extrapolation of what we're talking about here.
And I disagree with you, but
Okay.
you know, we both have that ability. But the point is, I could not have said it.
Okay, so
better.
what is your suggestion?
You have it in your packet. You absolutely have it in your packet.
Okay.
All right.
Well, you want me to read it to you?
No.
It's the one that Priya puts forth.
No, we've got it done.
Okay. This is a big deal for an industry that is already beset by liabilities.
Of course, it's big. That's why we're all here.
So this
We
is
know it's a
not,
big deal.
this is not a bargaining table as to whether we do liability, excuse me, liability limitation or defense without limits. This is maybe we don't need E&O. That would be one of the things that we'd stand for at Priya. We think we didn't need it to begin with. We think the wise decision is to have it.
And that's what I was getting at. I just want to know what your end result
That's
was.
right.
So your ideal is just we don't have E&O.
That's right.
Okay.
So you agree with Paul Roebuck's position, basically?
Yes.
Okay, all righty.
Diane?
Thank you.
I'd like to get clarification on one of Mike's comments. You said, and I want to make sure I understood what you said, that if there's a claim on the recovery fund, that the commission has let people continue to work, and I don't believe that to be the case.
No,
The only-
that's not what I said, Brad. Let me say what I said.
Let me finish.
Okay.
You said that the commission's been very generous or liberal in letting people continue to work while they paid that back, and I don't believe that's the case. The only time the commission, in my understanding, has done that is when there's an action, penalty action from an enforcement action, not from the recovery fund. Is that not correct, Christian?
Well, let's,
There are instances when the recovery fund makes a payout that when staff goes to enforce that license holder's obligation to pay the fund back, that staff may negotiate or has the discretion to negotiate a payment plan that would allow the license holder to keep working so long as they're making payments to repay the recovery fund. The issue is that Trek is not a bank. So the instances where staff does allow for that are few and far between.
I was not aware that staff had ever done that except on enforcement actions, and I know they have on enforcement actions.
When I arrived in 2009, there had been a couple of instances of that previously, prior to that time. And so I asked at that time that we make a very serious, that we look at that very seriously, that it be the absolute last resort, because we're not the bank. Okay, so if you have a judgment and you haven't protected yourself, it's not our job to protect you. Right? So we absolutely have had individual inspectors in the past who have come and said, the only way, I'm either out of business or I'll never be able to repay. Okay? And so under prior administrators, there were at least 2 times that I'm aware of that has happened.
Has that happened since you've been administrator?
Not that I'm aware of.
Thank you.
I don't believe it has.
Thank you.
Okay. Yes, sir.
No, I was gonna take back my 3 minutes.
Oh.
From my-
I don't think anybody else is speaking.
Did you have anything?
No, I'm gonna take those away.
Oh, okay.
I would like to make a comment with
Sure.
Jim Price here, to the Deputy Attorney General, counsel over here, basically. Back in 2009, I believe, Texas passed a loser pay law, which would help, it helps protect the recovery fund, the inspector, everyone else from frivolous lawsuits. It's a means that's out there that helps us as well for protection, okay? And means if you sue me and you lose, and I go back to you and I get all my fees back, basically, okay? So there's that level of protection that's out there as well. And how that fits in, I'm so confused after the last 20 minutes here that I'm not sure where I was going with that, but I wanted to throw that into the mix when we're looking at liability type issues, because it helps limit some of the liability that we have.
Well, I'm not sure what you mean, what you're referring to when you say that in 2009 the state passed a loser pays law.
Right.
I'm not sure exactly what statute that you're referencing. There are times in some lawsuits that a court may award attorney's fees to a defendant if the court finds that the lawsuit is frivolous. That is something that has been in place for many years, even before 2009. So without knowing precisely what statute that you're talking about and seeing the language in that statute, I really can't speak to how it would impact.
Do we have a means of looking at that while we're here, though? Discuss.
Expanded.
Law 360.
It's right here. Try Law 360. I'm not sure. Oh, here it is. Yes, right here.
It must be true.
But is it really pertinent to our discussion today?
Probably takes you into it.
No, Mike's done talking. It's okay.
Actually, well, Kristen, can we,
Take a break.
are we at a place where everybody wants to take a 5-minute break?
Let's do that so she can look over that.
Yeah, I don't want, she's kind of broadside here, so, okay, 5 minutes. Okay, 5 minutes.
You know what I'm talking about. But have you heard some of them?
Let's keep focused on our mission, not all the other temporary stuff.
I got like 3 more people that want to speak.
Let's stay on focus here.
Do you want me to respond to
Yes.
the question?
Yeah, so we'll start with Kristen, pick up where we left off.
Okay. In 2011, the legislature expanded tort reform in Texas. And as a result of the law enacted in 2011, the courts granted authority, or were given authority to award attorney's fees to the losing party. So that's the idea of the loser pays. In addition, that law also instructed courts to develop rules for dismissal of frivolous lawsuits early on in litigation. So 2 years later, in 2013, the Supreme Court adopted Rule 91A. It's Texas Rule of Civil Procedure 91A. It allows parties to file a motion to dismiss within the first 60 days that a lawsuit is pending. And the grounds for that motion is that the lawsuit is frivolous. If the court denies that motion, then the prevailing party gets attorney's fees for having to fight that motion. It's been, well, according to this article on the internet that was published in April of 2015, so 3 years ago today, or not today, but essentially 3 years ago, rules under, or motions filed under Rule 91A are not widely used, and the article is urging that they should be filed with caution because of the unfamiliarity of the process at that time. I'm not aware of any law or any cases dealing with Rule 91A motions to date. I haven't looked into that, so I can't speak to, you know, what the courts would do. But basically, it's just a tool. It's a procedural tool for the courts to use.
Thank you. It seems to me like our mission today is to address, which we're trying to do, the financial responsibility, which is, what do we want to do? Do we want to keep E&O where it is and not change anything? Do we want to get rid of it and only have the recovery fund? Or, well, that's two things. What's the third thing? It's really E&O, GL, or recovery fund and get rid of insurance completely. So we need to stick to that. That's item A, and A and B actually. And so we need to keep moving on. I've got 2 more people to speak, and then I think the committee, or 3 more. Then the committee needs to hopefully come up with some action item on this if we're going to.
Madam Chair,
Yes, sir.
may I just offer one little comment?
Sure.
Because it came up in the interim. So I wanted to make sure that everyone who's involved in this clearly understands that whatever the recommendation of the committee is to the commission, in the end, it's a recommendation for a position to be taken at the legislature. So there's no guarantee that anything will be done.
Right.
That anything will be changed at all, because there's nothing that we can change by rule given the requirements that are currently in the statute. Okay, so we can offer clarification, but if you want change, it has to come at the legislature. And so that really is the beginning of this process. Was it appears there are question marks around inconsistencies between the requirements in the statute, language in policies. All of the history is relevant on how we got to, exactly where we are. But we can either continue to, run in place, expend a lot of energy, or we could perhaps, and I think this is the committee's objective of trying to do this here, is to see if there is a sense of the industry where we could say the majority of industry members, with considering both their role in serving their clients and the commission's role in protecting the public, here's the position that we would like to see. And would you please advocate for that at the legislature, assuming that the committee agrees and the commission agrees, and then we have no clue what the legislature will do.
Absolutely.
Right?
Right.
But we know that all of our statutes are going to be looked at this year in sunset. And that's why we put all those questions on the table in our self-evaluation and said, these all require some input from the legislature. Here's the time that this is, you're going to be looking at it anyway. If you would like, this is the appropriate time to do it. So.
Thank you.
Yeah.
That helps. Okay. Sam, and I can't pronounce the last name. Okay. Okie dokie. Steve Demney.
I'm Steve Demney with Square D Inspections out of Elton. And there's three givens in life, and that's insurance, interest, and cracks and slabs. Cracks and slabs, that contractor's not licensed or regulated. We're all here today for the protection of the consumer. And we go increasing limits. You know, Texas, a $100,000 house is equivalent to $300,000 in California. So that chart there should be relevant to which geographical area you're into. You go increasing premium rates, limits and liabilities, you increase costs. All those costs are rolled downhill to the consumer. So ultimately, it's the consumer that's going to pay for these increased rates. They're not required to hire an inspector, nor are they required to hire a realtor. But if they do, we do it for their protection. Now we're going to charge them more because any costs we incur, they all roll downhill. If it's not broke, don't fix it. I'm not aware of any issues where we felt the consumer, or what even brought this about, or all these discussions. Is there a problem? I'm not aware of it. Just because everybody's going to eat ice cream and you don't want ice cream, you don't have to go eat ice cream.
Good point.
Okay. And then we have Nick.
Good morning. Again, I think in the similar terms here, I don't know when we look at the number of inspections that happen versus the number of claims that happen. Obviously, the number of claims, or the number of dissatisfied clients is extremely, I was saying extreme, is higher than whatever makes it to any litigation, whatever makes it to Direct Real Estate Commission. And how is that? Well, that's because as responsible inspectors, we take care of the things that we don't do it right. We miss something, right? The only time it gets here is when somebody just told somebody to go jump in the lake, or it is completely frivolous. And if you haven't been in one of those yet, you will. It is inevitable in this industry, right? So my concerns here are, one, I think that, was there any education requirements involved in this particular understanding? I'm assuming that this here is designed to give us an understanding of what those limits are as arranged to other parts of the country. Is that an accurate statement?
We as a committee requested that staff pull together information so that we could see in the chart what other states are required.
Okay.
And obviously California is not in this because California has an association that represents all of their inspectors, not several associations.
Sure, but it's not required.
But it's not required.
So 34 states that are regulated, does that mean that those are 34 states that have licensing requirements?
Licensing requirements
Okay,
or some
so
regulation through a statute with their legislation.
My contention in part of this is that if any of this discussion talks about raising the limits, which we just alluded to, I have 7 inspectors, and my insurance is more expensive than somebody that has 1.
Right.
So just like anybody else that owns an inspection company, your costs are going to go up. Where's that cost going to go? That cost is going to end up at the consumer, which is counterproductive to what we're doing. If the education, I would be very interested to see what the education requirements are, what the license requirements are, as opposed to what the limits are. Because there are, out of the 34 states that have regulated inspectors, there is a number of those, a percentage, that the licensing requirement is a form and a fee. Not 400 hours of education, not whatever our current ride-along number of hours are, not the education that we have in Texas. We are the most strict state when it comes to licensing. Therefore, why do we need to have ourselves compared to states like Florida, where you fill out a form, maybe you take a 40-hour class online, and you send in your fee, and now you have a license?
Name the state, we have the information with us right here.
That's what it is. What is Florida's regular? What is their training?
Training for Florida,
What is their requirement for license?
12 hours.
Boom.
14 hours annual.
Is Florida on this list?
Yeah.
What is their policy on insurance?
300K jail.
General.
300,000. Boy, isn't that ironic? You have very little bit of education requirements, so your limits are higher. Why do you think that is? Maybe there's higher homes in Florida. You go to Miami, you go to some of those areas, there are higher end homes, there's no doubt about it. But if we have a track record in this state of not utilizing the fund, whether it's difficult to get to or not, if someone is going to that extreme, they will get to the fund if they really want it. Otherwise, we've handled it, our insurance has handled it, whatever our own internal attorneys have handled the situation, we have gotten there. There's no need for, I am absolutely not opposed to a requirement for some type of insurance, but I am opposed to a requirement on the amount. If most companies wouldn't write less than 100. It's not worth it to them. So if we have that, then that's our base. You have to carry at least this. I carry considerably more than that. But that's my business choice, right? This is no different than a lot of the other discussions that are going on in the world right now. This is our choice as business owners. This should not be a legislative choice.
Thank you. Clap on that.
Well, we got more discussion. I mean, all right, so we've everybody's kind of hem-hawed around and throwing our little 2 cents in. So in an effort to try to bring A and B to some sort of motion and or action item, what about just tossing out from a committee standpoint what our thoughts are as far as just A, B, and C, or A, B, what do we want? My first thought is I don't think we should go. Sorry?
Before we do that, I just wanted to remind the committee in the materials, at the last meeting, y'all asked for staff to develop a survey that we could ask to license holders. And so we have put a draft survey in there. And before the committee goes around and states its input based on this one meeting of comments, you may want to think about a survey and getting more input from license holders who may not have been able to be here today.
So has the survey gone out? I can't
No.
remember.
No, it's a draft
This was the
for,
draft of the survey.
the working group to,
And this will go to every inspector in the state?
Correct.
Okay.
that's the idea.
And what do you think our time frame is for requiring it to be, I forgot
Well, I mean, it depends on when you send it out or when we approve it, and then when you want, or how long you want to give stakeholders to respond.
Well, here's kind of my thoughts on it. I think the survey is a great idea. However, I don't want to leave this meeting without having some direction to not only for us as committee to have a direction that move forward so that we can, I would like to have something for us to recommend to the full inspector committee for recommendation to the commission. Now, in between that time, we can send out this survey, and at the full committee meeting, take results from that survey, and if they come out and show that we're completely out of line with where every other inspector in the state wants to be, then we can adjust accordingly. But I have a funny feeling the amount of representation we have at this meeting with the inspectors that are here and the associations that are provided, I think we have a pretty good base as far as where everybody's standing with a lot of this.
Okay, our next full inspector committee meeting is April 9th. So we
can't.
get anything done in 2 weeks?
Probably can't. Sure.
No.
We can.
Absolutely.
Mr.
Well, I mean, if
I don't see why not.
The day after you approve this,
yeah, we can
We'll
send
be
it
out,
out,
Okay.
and
It'll be
then
out next
we
week.
can,
They had a question.
Do we have that survey?
we do. We just
we
pulled
can-
up on the
Yeah,
screen.
we have a draft copy. in
It's
our
on page 11.
So it was on the agenda material.
And, just to go through the questions on the draft survey, and this is, none of this language is in concrete, so if you want to change anything, please feel free. So the first question is, should the inspector recovery fund be maintained? And it's simply a yes or no question. Yes, maintain it. No, repeal it. The next question is, if you decide to maintain it, should the claim amounts be increased from $12,500 per claim, $30,000 per license holder? The options are yes, increase to $2,550, $50,100. That's the same as the real estate recovery fund claims. Yes, increase to some other amount, or no, the claim amounts should remain the same. The next question is, should the insurance requirement for inspectors be maintained? Yes, maintain it. No, it should be repealed. Then, if the insurance requirement is maintained, should the statute be amended to specify the type of insurance? And I guess we should insert the word policy. Yes, general liability coverage. Yes, errors and omissions. Yes, both general liability and errors and omissions coverage. And then no. If the next question, if the insurance requirement is maintained, should the aggregate and per occurrence amounts, and that should be reversed, should the per occurrence and aggregate amounts be increased from the current 100,000, 100,000? Yes, increase to, and these should be reversed.
Yeah.
100,000 per occurrence, 250,000 aggregate, 100,000 per occurrence, 300,000 aggregate, 250,000 per occurrence, 500,000 aggregate. No, the current required limits are sufficient. Now, we could put another option, and I think we probably should, before the no, to say, yes, make the limits some other amount, similar to what we did in question 2 for the recovery fund, and allow for stakeholders to provide, their suggested limits. And then the next question is, given that the statute currently requires inspectors to provide $100,000 of financial responsibility, should an insurance policy allow for the defense cost to be paid within the statutory limits? Yes, but only if the required per claim amount is increased, and then no. And then the last question is, given that part of the commission's charge is consumer protection, is it appropriate to allow an inspector to limit his or her liability in a contract with a consumer? Yes or no?
Now, although I think the survey questions are reasonable, I know how just about every inspector who just gets this email is going to answer those questions.
Yeah, I know.
In reading through that, without, because they're, the people that are here are taking their time because they not only believe in their own, company and their own selves individually, but in the consumer, and people that are here and making an effort to do this, we have all the background information. When we send this survey out, they're not going to have a...
We love you, Lee.
That was just an opinion, go ahead.
I called a clown before, it's all right. But we said...
We're going to get unknowledgeable answers.
Yeah, we send this survey out, they're not going to have any background information. You send, 3,000 other inspectors, should the recovery fund be maintained? No, I want my money back.
Yeah.
Should we have insurance? No. I already know how they're going to answer. I don't mind sending it out and using it as later on, just to have an idea. But I think I already know exactly how they're going to answer it. I don't think that they're not going to have the benefit of any of this background information that we're talking about.
If we're going to send a survey, we need to send some supplemental data with it, explaining the pros and cons of each section. In my opinion,
theory, they would read it.
Well,
Yeah, that's the problem.
if we can teach them to read,
It's hard enough to get people to respond to surveys without, and just because being part of Terry and my background with sending anything to association members, out of 300 people, 25 people bother to respond. That's the only problem with surveys. It's never really truly a representation of the people you send it to because they're too busy or they don't care or whatever. So, I'm sorry.
I think we all in this room can agree with what I'm fixing to say. There's Frida, Terry, in the room, we carry more than half the inspectors throughout the state.
Correct.
And if we're here representing the same agreement on both sides of the table, I think we can go forward.
Kind of
Instead of beating around the bush.
And not do the survey.
Not do the survey. Do we agree?
Yeah.
The problem I would have with the survey is if it gets sent out and everybody, and I agree with Lee, on how they would probably fill it out if we don't follow their recommendations because we don't think it's right, then the industry as a whole doesn't feel like we're bagging them.
Right.
Yeah.
There could be some serious backlash. Like I said, I already know how they're gonna answer it, and just looking at them, oh, nope, 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 nope.
Yeah.
That's what they're gonna do.
Yeah.
But as an inspector committee, our task is consumer protection first. And I understand all of the inspectors that are here and all of the inspectors that would get the survey. You know, as also having a business for 15 years, I understand, you know, both sides of it. I see that, but as a committee, you know, we have to make common sense recommendations that protect the consumer, which is our job, the way I see it. And when I go to an inspection every day, my job is first and foremost protecting my client from doing something or making a decision that could be irrational. You know, so I feel like, you know, we all have our heart in the right place, but as a committee, we also have to take that as first, and our businesses and how we choose to run our businesses as our secondary.
I think there's been enough emails that have gone out between TREC, trade associations, and everything else that any inspector who wanted some input on this has had more than ample opportunity to either show up like everybody did here today, email in if they couldn't be here, whatever the case may be. I think the survey, if we send that out, it's going to be counterproductive. I think it's going to cause more problems than.
I think it's just gonna it's just gonna dilute.
For me, kind of going back to what I was really starting to talk about is kind of my thought process on a direction we could go. I think if we keep the E&O and add the G&L as a rider, the cost is minimal to add that as a rider. So I think if we, in my opinion, and it's certainly subject to change with good argument, but in my opinion, I would recommend $100,000 per occurrence, $300,000 aggregate with E&O and G&L, and getting rid of the recovery fund.
Repeat that again?
To do a E&O and GL, $100,000 per occurrence, $300,000 aggregate policy, minimum requirements, and dissolution of the recovery fund.
And leave defense within limits.
And leave defense within limits, yes, thank you.
The only comment I have to that is, why do we at TREC feel like that we have to take an additional step that all the other agencies do not take in the state to protect the consumer?
Well, I'm also trying to be a realist in that I don't think that if we ask that the insurance go away, that's going to happen.
I'm not advocating that, but I'm advocating getting rid of the E&O requirement. I'm not in favor of putting that.
Because, and I think in the conversations that we've had, you know, like I said, our job here is protecting the consumer. And E&O and GL typically cover different things. And as long as we aren't making one 500,000, the other, you know, $1 million, or, you know, really getting crazy with the numbers, as a business owner, you can put those limits wherever you want.
Yeah.
You know, you had mentioned you have much higher limits. I completely understand. As a business owner, that's absolutely your right to do so. But from a state perspective, I think if we just keep it right there, because based on the numbers that we've seen, based on policies and claims that have actually come in, I don't see any reason to bump it up, the minimum requirement above 100,000. So, but I think if we have E&O and GL, I don't think adding the GL as a rider is that huge of a cost by any means, as opposed to bumping from 100,000 to 250,000.
And 100, 300 is the standard policy, right?
Which should conform.
Either 100, 100 or 100, 300 are standard policies.
100 is also,
There's- yeah,
okay.
there's
Well,
no-
I remember the impression
no-
that wasn't
no
a standard
difference there.
policy.
100 is not a standard policy. In typical insurance policies, the aggregate is always higher than the per
There are, but in
occurrence.
professional liability, that is not true. There's million,
well, based
there's
on the
100, 100, there's 300, 300. It's however the company chooses to write it.
Based on the information that we were provided with insurance agents that write this coverage, as well as the Texas Department of Insurance, that's what we've been told.
Well, whether it's a standard policy or not, I kind of look at it as 100,000 per occurrence, 300. If somebody's really just muffing up and, you know, screws up 5 times a year, we want to have some protection for the consumer that all 5 of those consumers can be, at least come close to be made whole.
Deal.
I mean, I think, regardless of whether that's a normal policy or not, I think that's irrelevant. But I think if we add the GL as a rider on that, the cost, there's of course going to be an increase if you're adding GL, if the inspector doesn't have that already, because a lot of inspectors who have that will. But you also have to factor in that there's going to be a number of people out there, licensees out there, that are only going to do the absolute bare minimum of what that statute is going to do, and no more than that. So I think if we factor in the E&O and the GL for that, with those limits, I don't think the cost burden to an inspector is going to be that much, but I think the protection for the consumer is exactly what the intent of the statute was in the first place.
Right.
And then at that point, the recovery funds moot.
I don't have a problem with the GNL, I just don't see why we are held to a higher standard than a doctor who's performing a lot serious operations than we are.
That's
You're
a
not.
whole different ballgame.
Well, I mean, engineers are not?
Yes, they are.
No.
Yes, doctors have,
Doctors
requires an E&O and negligence.
I mean, according,
As a prerequisite for licensing.
Yes, as a prerequisite for
the
licensing.
Engineers Association requires GNL.
But we're not
Architects are-
engineers.
I know, that's what I'm saying, they're performing. I just think that we're being held to higher standards than.
You're
than a lot of other
you're not
associations.
being held to a higher standard. As Mr. Reagan testified earlier, he works in several different industries, air conditioning, pest control, application, and they have insurance or financial
But not
responsibility
Not E&O.
requirements.
Not E&O.
It's only GL, because I'm an electrician
Right.
also, and it's
It's not
only
E&O.
GL.
That's what I'm saying.
But they're not
There is
also
no
writing a
detailed
report
policy.
for somebody, and we are. I mean, I'm not, I'm
Yeah.
just being the
Yeah, yeah.
devil's
I
advocate
know.
here, but we're going into a house, and we're looking at everything we can possibly do by our standards of practice. Whereas an electrician goes into a house, and he's usually called because it's a specific thing.
Right.
And he doesn't put a report together, and he doesn't create some analysis and some summary of the condition of something.
We're not telling
and
the
make-
consumer, giving them information based, to help them based on whether they're going to purchase that home or not.
Right.
HVAC electrician there, my AC doesn't want, come out and fix it.
Right.
Yeah.
You know, they want the insurance there is, if that guy puts his foot through the ceiling, if he screws something up,
Yeah.
well, not for us. We're giving somebody 20, 30, sometimes 100 pages of a report, to help people give an opinion on whether they should purchase that home or not. And that's how a lot of that is perceived. And as much as I don't like the E&O, I think from a consumer standpoint, that's probably still a good thing to have from our side.
Lee, can I ask a question? Make sure I understand, you're proposing an increase from 100,000 to 300,000?
No, 100,000 to 300,000.
Keeping it at 100,000 per occurrence. Currently is, we're requiring 100,000 per occurrence and 100,000 aggregate. My only increase is still 100,000 occurrence, but 300,000 aggregate. So if there's multiple issues there within that year, within different consumers, they can't be capped off at 100,000.
Has there ever been an issue where that, the way it is currently, has not been
We don't
sufficed
get
with
that.
the consumer?
We don't get that
There's no
kind
way
of
to know.
information with TREC because TREC has no idea when insurance, when insurance companies have had a claim.
So why are
on
we
it.
debating this?
Well, your cost difference is pretty much minimal when you go
Yeah,
to
but
that
what I'm saying, is whatever cost increase will be passed on to the consumer, and it might be.
It's
my
pretty
premium
much
20%,
minimal.
Right, but you look at your car insurance.
For an
And
inspection.
if you get in an accident, usually it's what, 25, 50?
I don't know, just leave it alone.
Minimums are, something like that. But it's per occurrence and then aggregate, in case you get 2 accidents.
I think we need to look and see if there's ever been an instance where what we have now has not been sufficient.
There's
But if you
real,
write it this way, your insurance will actually probably reduce if you take the minimum, because it goes into a standard policy instead of being a mixed match. You gotta look at a plus and a minus. What
Do you see the insurance rates coming down because of this?
I don't know if it'll go down,
But I don't think so.
especially with the GL rider on it, but I don't see
The insurance company is gonna have to reinsure an additional layer of insurance to go from 100,000, 100,000 to 100,000, 300,000. So there's going to be a price increase. It should be nominal.
And again, that's passed on to the
Actually,
consumer.
we have actually received conflicting information. Some insurance carriers have told us that the cost will go down if we have a standard policy where your aggregate is higher than your per claim amount. Other insurance companies have said there may be a slight increase. So
We're getting that from agents, are we not, rather than insurance?
no,
There's
we've
no-
received information from TDI that was presented to the inspector committee, and that I can pull that up from a previous meeting, but the information is not clear in that regard.
There's no logic there because they have increased liability, they have increased risk, they have to charge more.
Well, and I'm not disputing your comments, I'm just telling
Yeah,
you
I'm
what
just-
we've been told by
Right,
the
but
Department of
I'm
Insurance.
just saying there's conflicting issues, and from a practical standpoint, and as a practicing insurance agent, that's not gonna happen.
I'm just trying to look at it from a balance standpoint. We have to find
Sure.
the right balance of what, I don't want to overburden inspectors with having a bigger, this huge deal on that. And I also don't want to overburden inspectors by putting a huge target on their back by bumping the limit to 250 or 500,000.
Right.
So I don't want to do that. And I don't think making the aggregate 300,000 puts a bigger target on the back. I think it's just an extra protection for a consumer if that inspector screws something up multiple times in that year.
And Lee, how many consumers has been harmed with the limits that we have right now?
I'm sorry?
How many consumers has been harmed or tried to reach more than 100,000 aggregate right now? Do we have anything on that, or we just throwing out a number?
There's really no, unless we can get every inspector in the state to fill out a survey that says, how many times have you had to, have you been sued, and can you tell us how much money you paid out, or your insurance company's paid out, and how many times in a year, we can send out a survey like that and get people to give us that information, but Trek can't collect.
You're not going to get that. That's what the whole point is. I mean, it's like we talked to earlier, the surveys, it's going to almost be pointless.
Right.
But
I'm saying-
so is increasing the aggregate on the insurance. I mean, we don't have any proof either way, so why jack with it if it's not broke? Leave the thing alone.
So leave it at 100,000, 100,000.
If we got to have E&O, leave it alone.
Yes, correct. If it's not broke, don't fix it. If there's no
And
issues,
for
why are we
you-
debating it?
okay.
I mean, I think having a requirement for insurance is a protection for the consumer, just in the standpoint that it eliminates a lot of guys that want to do one inspection a year.
Yep.
Or 2 inspections a year, or a guy that was a roofer that decided he wanted to be an inspector and went through all the process that we require, but doesn't do enough work to pay for a policy. That is a consumer benefit.
Yes.
And for us, I think there's an opportunity for that. But if we don't have any evidence that shows that what we currently have is not filling the void that's there, or not filling what consumers are needing, and Trek obviously doesn't have that information, whether it's easy to get or not easy to get, there's no sense in changing it. It just doesn't make any sense to me. I don't understand the logic on why we're spending all this time on it.
So do we want to just put in the statute, make a recommendation to clarify the statute to say errors and omissions? 100,000, 100,000?
I would support the idea of leaving the insurance where it is. Whether we jump it up or not, doesn't matter to me. But what I do think, we don't need E&O and our general liability and recovery fund. The recovery fund is fruitless. It's a waste of time and effort regardless of what the trade associations think.
So what if we were to leave it at E&O, what if we were to leave it at E&O and GO, 100,000, 100,000, and getting rid of the recovery?
I'm 100% in support of that personally.
Okay.
Okay,
So
so.
I got something too.
No, you're dead on.
Sorry,
Yeah,
that was just a
you're
hallelujah?
dead. Yes,
Okay,
absolutely. Praise Jesus.
Now, you're saying add G&L?
Correct.
But take away the fund.
Take away the fund.
Yes, sir.
Thank you.
Time limit.
Remember, there's a limitation on
You're getting more
time.
like me every day. Cochran School of Bloviation. I think I've heard it more than a dozen times here this morning that we're here all about the consumers. But if you do that to the damage of the industry, it's like unwritten part of that statement. That's not good either. I think it's also a stretch to think that we can't make a repeal a possibility. I think that a recommendation to the Sunset Committee might just produce that. So I think it's a stretch to say it'll never go away. And finally, in terms of the polling, the survey, I don't know that that's a bad idea, and it's because of a discussion during the break with Doug, and that is stakeholders I think you're ignoring the stakeholders. Yes, these guys are all interested here, but I tell you what, there's more that wish that we were live streaming today and would like to hear what's going on around here. Finally, I think it's also a stretch that one meeting on these topics, there's such magnitude, should produce a result or a motion to go on to the next level. I think you've got more deliberations to be done. If we should decide to do a survey, there are two questions that are strikingly not on here, but I'll retain those until the survey question is answered. Diana.
Okay, thank you.
Well, one point is, number one, this isn't the only conversation we've had about this. There's been a couple, to say the least. Yeah, so, and that we're ignoring stakeholders, I also don't agree with, because not only has this not been the first conversation that we've had about this, but I know I've personally received multiple emails from the different trade associations regarding this, and insurance companies regarding this, who knew a lot less about this, but are sending me emails telling me how Trek is the big bad wolf and trying to screw everything up. Plus, this isn't the end of this. This is, what we're here to do is to try to come to a consensus, to give a recommendation to the full inspector committee, to then recommend to the Trek commissioners. If stakeholders still want input in this, they have plenty of time still to do so. I think there's still plenty of other meetings in which if they have genuine input that can have an impact on how this goes, they have that opportunity to do it.
Thank you.
I have a comment that Mr. Cahill sent that he asked me to share, if I may. He said he understands that I must pay for anything that I miss in the SOPs up to $100,000. He says, is that right? On every job, for how long, and put the consumers and inspectors on the same page and make the expectations clear. So there is some concern of how long are we liable for a home and something that we missed. And the question is it right that we get paid a few $100s for the job and yet we're liable for $100,000 for a loss on the house or a claim against us?
I don't know that we're liable. You're not liable for $100,000. Your insurance company is.
Well, we're liable for damages. We're liable for damages. You're liable for missing something in the SOP based on the recommendations of the matrix. If there were no damages, but you missed something, I mean, they're two different things. I think the $100,000 is for damages, not necessarily missing something, although it might be for missing something.
It could be an omission. Could be, yeah, it could be.
What is the statute of limitations, so to speak? It's like 2 years? 2 years. So that question is already, that answer's already been out there. I mean,
Plus, most agreements say it's good.
I believe the statute of limitations, at least for bringing a complaint, is 4 years from the date of the inspection.
Oh, okay.
It would differ in a court if you're bringing
It's
an
a date of
action.
discovery, is it not, Christian?
No, it's from the date of the inspection report.
For an action?
No, for a claim,
enforcement.
for enforcement
But
action.
from a legal standpoint, it's from the date of discovery, is it not?
Yes.
It depends. The
lawyer speak.
Boy, that was a good lawyer answer, wasn't it?
I think we're kind of getting off track here.
I mean, it does.
We're kind of going a different direction.
You know, the recovery
where we
fund
go.
does specify that you have to bring an action from 2 years from the date the cause of action arises. Typically, we would look at the date of the inspection report as the date the cause arises. So 2 years from that date.
So your 100,000, 2 years.
Well, I don't think that's very clear in the education or anything else on it, because whenever those classes are taught, we've always seen that it was 2 years from the date of the claim that the issue was found.
Well, what can happen is it depends on what the inspection report says about the claim at issue. For instance, if the inspection report highlights a plumbing problem and recommends that you go and get a plumber to inspect further and give you more information based on what the inspector found, then that's enough to put the person getting the client on notice that there might be a problem with the plumbing. If a plumbing problem is later found, we're not looking at the date that it's later discovered, it's still the date of the report, because that's what put the person on notice that there may be a problem.
All right, well, I think we're kind of going
Okay, we kind of.
way off a whole nother road here.
Yeah, that's okay.
And I'll be sure to thank Mr. Cagle.
Okay, so.
I think he's got a message for you too, Leland.
I'm sure he does. I don't think we can say that in
read
the
it.
meeting, though.
All right, so our task here is then to determine on A and B, we want to basically send to the full committee a clarification of the statute language, which specifically, instead of just saying liability, let's clean that up and say errors and omissions and general liability 100/100. Is that what we want to say?
And a removal of the recovery fund.
And the removal of the recovery fund. That's our recommendation to the full committee.
And within limits?
And
With the defense within limits.
And then the contractual item
Which I don't know,
C,
well,
which is.
do we have to specify
oh,
that? I
sorry,
mean, it's already
defense-
part of the policies anyway.
Defense within limits.
It's
See,
obvious.
Clark,
Well, it's a good
Need to
clarification.
clarify.
It's a good clarification.
That's what started the whole thing.
Okay,
Yeah.
that is what's
You're
in.
right. It's good clarification.
Okay.
And
so
that's to reimburse the inspectors for the money out of the recovery fund,
That's how, if that comes back, that's
not going to the state general fund.
That's my understanding. Is that
puts in
right?
what they initially put into it.
So, yeah, I'll address that. The way it was drafted the last time, when it was actually proposed for legislation and then it got pulled down, was that everyone who held a license at the time of the repeal, okay, everyone who held an active license at that time would receive their, of course, it used to be $100, right? It has since been reduced to 10, but in any case, would receive $100 back. So if we have,
No interest?
no. No interest.
Every inspector will receive 100 or what they put in.
No one,
The way it was written was every inspector who had a license at the time would receive $100, okay? Would receive $100, that's the way it was written. And then everything else after the payment, there's a time period of payment of latent claims, right? 2-year period.
Right.
And at the end, the rest of it went to
General fund.
the
Divided
general
among
fund.
the other inspectors.
General fund.
And the funds.
But if you haven't, I'm sorry.
After that 2-year period, the balance would be dispersed equally between each inspector?
No, everybody gets back what they put in. At the time, that was $100.
But that's still gonna leave a couple $100,000 in the bank.
It ends up going to the general
It's not
fund.
really in the bank. So, yeah.
After the payments are
We
made.
don't have our own bank.
It's only about 20 grand, guys.
No, it's a lot more than that. It's about 200 grand. isn't it?
There's, well,
Can't go back to bank.
I'll make it really simple, okay? Legislature's not gonna give it all back to you, okay? Sorry, they're just not.
Yeah.
Yes, we understand.
They're just not. They want it, they get everything over 600,000, which is the reason we reduced it from 100 to 10, because we were just putting money in the general fund every year.
Right,
Right?
At the time that was drafted, Doug, though, weren't all recovery fund payments at $100 coming in?
Every new license holder was paying $100.
So
That's right.
I'm suspecting that we would change it to the amount paid in.
That's a recommendation. We certainly can go back and say, let me see, you got your very first license here. Well, let's see, if you got it back in, like, if you have license number 5, right? You probably put in $200.
Okay, well, before we
Okay,
get too far on that
Right.
tangent, that's gonna be a whole
Right.
separate thing that they're gonna have to do. So if you're concerned about how much,
I'm
what
not-
gets divvied out of the recovery fund, then go to that meeting.
Yeah. Okay,
It's just,
so for right now, let's stick to A and B, which is that, and then let's make sure Brad and everybody that's on the committee, and Stephen, and Barbara Evans is also still here, I think, that do we want to just send a recommendation that we're clarifying the language in the statute, specifying, instead of just liability, that it's going to be E&O and general liability, 100,000, and removal of the recovery fund, and make sure that the insurance is defense within limits. Okay. Is everybody on the committee?
No, I'm still confused. You say E&O and general liability, were you talking 2 different policies, or could it be interpreted
GL,
as that?
right.
GL, like they said before, GL will be a rider on the E&O policy.
With the same limits.
With the same
With the same
limits.
limits.
Correct.
So it's not gonna
Two
be
coverages.
100,000, 100,000, it's two coverages, two policies.
No.
No.
One policy with the GNL, with the general liability being a rider on the E&O policy.
That's how I
Adding
understand it.
GNL to our burden
$100,000
now.
aggregate.
I'm sorry?
I know, I just understand how it's interpreted.
Yeah, exactly.
Taking away the
I
recovery.
wanted to clarify.
Talking about a few $100s.
If you go
If
back,
that-
if you
No.
look, if you look back at the different state, some of them require both GNL and E&O, and sometimes the limits are different, and sometimes they're the same. So what I'm hearing is that the limits would be the same, you're just requiring the policy to have both types of coverage.
Correct. And clarifying that defense within limits is allowed.
Yes.
And as a result of adding the GNL, getting rid of the recovery fund altogether.
Okay.
Can I
And so
ask
there's
our
no-
insurance guy to clear that up even clearer for us? I mean, just so that everybody in the room
Yeah, I mean,
understands that.
it could either be a rider or two separate policies. And that would be up to your carrier and how they do it. Some carriers won't add the GL rider, some will. So it'll, there's multiple ways it will be depending on your specific carrier, but both policies are available. And typically, the GL can be written as a rider.
So basically, one policy
One
gets with
policy
the
with the rider and,
Okay.
yeah.
Yeah, I just want to clear it up
Yeah.
for everybody's mind and for mine. I'm getting old and can't understand it. So. Don't laugh at me.
No,
And
I'm getting old too.
Kristen, you had another clarification.
I just wanted to make sure that, so, you're not interested in getting any more information about the, per claim versus aggregate and that cost factor.
No, I don't think it matters. I mean, I think it's
Okay.
gonna be what it is.
I just wanted to make sure that that's where the committee, or where the working group was in terms of its recommendation.
Right. Do we all agree? Okay. Do we need a motion for any of this?
I'll make a motion to put that recommendation to the Inspector Advisory Committee.
I'll second it.
All in favor?
Aye.
Aye.
Barbara, can you
So
still
we're,
hear us?
she eyed.
Oh, okay. Sorry, I can't hear you.
Yep, she did.
All right, so we're going to move on to item C, which is contractual limitations of liability. And I want to open on this one that my insurance company requires that I send a contract with my policy when I update my policy.
Okay, hang on, before we leave the vote, I just want to make sure that that was a unanimous vote from the working members who are here. Is that?
Paul, did you
Not all
vote
the
yea or
working
nay?
members voted.
Yeah, I mean, were there
Well, I
any
kinda sat down
abstentions or
and
any?
was quiet Because I still, y'all asked earlier about the recovery fund. I said I'd have to poll our members to find out. So I haven't done that on that specific item.
So you're abstaining? Okay.
Yep.
Okay.
Okay, so on C, contractual limitations of liability and whether that should or should not be regulated by TREC. So my personal opinion is that because my insurance company requires me to have a contract and they ask for it, whenever I renew my insurance, and if I had a claim, I'm sure that's the first thing they would ask for. I feel like I'm going to have that contract no matter what, and I feel like that's a business decision on my part to have a contract with my clients that clarifies what I'm doing there and what I can't do and what I'm not going to do. And if they sign it, my agreement before our inspection, we're all on the same page, which is what I require for my business. Now I'm going to open it up for anybody else on the committee to give their ideas.
I'll just say real quick, I think it's already in the preamble that TREC's not going to be involved
Yep. In
with the
contractual.
contract, between the client and the inspector, and I don't think that should change.
Absolutely agree.
I don't think anybody wants to be involved in this.
In my insurance company, it's the same way. I just send them the contract to them.
Right, so Terry as an association does not feel that the limit, any kind of contractual limitations is something that we want to discuss to TREC at all.
Correct.
And we felt so strongly about it in the preamble, it's not only in bigger font, it's bold, it's, you know, it's right there.
So it's already there, so that's really an off-the-table item, in my opinion. Mr. Roebuck, what about?
I think we need to just leave it as it is.
Okay.
Leave it alone.
And from Ashy, Mr. Rozell basically said that, yeah, the same thing. So I don't feel, Kristen, that inspectors want their contracts or their limitations of liability or opportunity to do it limited.
And, you know, that's certainly the recommendation that the working group can pass along.
Okay.
The only comment that I would make is that the statement in the preamble does not represent the be-all, end-all statement on the matter. TREC does not particularly get involved in your contractual agreements with the clients that you serve. The only reason this issue came about was because that the legislature has already stated their opinion on the matter. And by requiring inspectors to have financial responsibility that provides up to $100,000 in liability, then the legislature has already made a policy statement on that matter. So irrespective of what the statement is in the preamble, there's a legislative policy statement that's out there. And it can well be argued, and perhaps even has been, that your contractual limits violate that policy statement of the legislature. And that's all I would say about that.
Well, then go ahead. I'm sorry.
No, I was just gonna ask, then can we add to that so that there's not that potential for a conflict, that we ask for specific language that permits it in the statute?
Permits what?
Permits
Contractual
limitations
limit.
of liability.
Okay.
Yes,
Yeah.
I agree that we.
So despite the fact that there is a requirement for E&O, which we're gonna endorse essentially, I mean, it was their decision, right? But despite that, we'd like also you to bless that we can contractually limit that, so that there's not that conflict.
Okay,
Are you okay with that?
yes. Does everybody
I'm not sure that,
It's essentially, we're going to be putting in the wording what it already says in our contracts, in the preamble.
In the
It'll
actual
actually be in the legislature.
Okay, because I mean, we're all under the same understanding that limiting our liability to the fee of the inspection is not preventing a lawsuit.
Correct.
That somebody that's gonna come after you for thousands of dollars is not gonna settle for $300 inspection fee.
Right.
Right, there's two totally different conversations.
Oh, we get it, right.
We're all on the same page.
Yeah,
Right.
yeah.
We have to
Thank you.
clarify in the session, probably.
So do we need a motion for that? Or?
Well, I mean, if your recommendation is to ask the legislature to clarify that and to allow inspectors to have that limitation clause in their contracts, then, you know, that can be the recommendation that you put forward.
All right.
By putting the recommendation out there, are we just opening ourselves to
That's
say?
right. That's what I'm afraid.
No, you can't do that?
Yeah, we've seen what
We
their
don't know because it's already in
interpretation
there. It already says no, we can't do that.
Who says it we can't?
It says it in our preamble.
No,
Yes, it does.
I know that.
It doesn't matter what's in the preamble, that's just a form that's been adopted by the committee. The courts could say that regardless of what's in your preamble, the legislature has imposed this requirement. So you can't waive it, an agency can't waive it simply by adopting language in a form, in a promulgated form. That's what I'm saying. Because the legislature has already made the policy choice to require you to have $100,000 of financial responsibility. So.
Right, but we can't go over that. It doesn't say we can't go below it.
Well, that's exactly what it says, because by imposing that requirement on you, it's basically saying, this is the minimum, this is what you have to do. So, you know, the legislature has spoken.
Agreed, but as individual business owners, wouldn't that be a violation of contract law?
No, it wouldn't. There are insurance financial responsibility requirements where if the legislature wanted to allow you to contractually limit those financial responsibility requirements, the legislature has put that language expressly in the statute. And the question here that the working group is considering is, do you want the legislature to provide that clarification both for you as license holders and for consumers? I mean, I think if you want to continue to have those contractual liability limits and you're going to retain the financial responsibility requirement, then those two are at odds with one another. So there needs to be some sort of clarification as to whether one trumps the other.
I mean, I can see it, because I've got it in my contract, or in my agreement. But at the same time, I look at it and it's like, I'm required to be liable for 100,000, but then I'm having them sign a contract saying that you can only get to me for the cost of the inspection. I don't know what good that one might be, except that it might deter the uninformed client that didn't know the 100,000 is there.
It's a red herring.
Well, I also think it's playing to two different issues.
Yes.
The financial responsibility part is playing for like a major screw up.
Right.
Okay.
This language in limiting your liability is the guy that comes in 60 days later and says, my water heater went out, you need to pay for it, or and you go, I'll give you your money back and we're fine.
Right.
Yeah.
And that goes away. So I think you're talking about two separate issues. You know, the guy that has a real claim that whatever it is, he's got a lawyer and he knows he can punch a hole in that in that contractual limit, no problem, and he's going to go on. But the guy that, you know, the water heater worked the day you were there and 60 days later it's out and he's throwing a fit because you should have known it was going to go out, it gives us as business owners protection against that guy.
All right, so playing devil's advocate here, if I'm an attorney for a client who is trying to sue an inspector, and I know that they have a $100,000 NGL policy, but they signed this thing that says you're going to limit the inspector, you agreed to limit the liability to that. As an attorney, I think where Kristen's going. As an attorney, I go, well, look, they can't limit your liability to $350 because the state tells you have to be up for $100,000. So this whole agreement is void,
Well,
and wipe out everything in that agreement.
It's actually more than that. It's called an adhesion contract. You can't require that anyway. So I may be wrong, but that's what I'm.
Well, it's an affirmative defense. Yeah. I mean, there's it's an element of the consideration. You know, did you read it? Is it posted? I mean, how many?
Right.
There's so many variables in a claim situation, but to the extent that a claim has been made and there was a contract limitation of liability in the contract, then if it was ironclad, then no claims would ever be paid.
Right.
Right.
Everybody would just get their money back. It's not ironclad. So all we're thinking that we should do is let the statute be clarified to essentially say these are not inconsistent, and take away the argument that that you so eloquently demonstrated, that said we're just going to throw out the whole thing because the 100,000 is the minimum liability that the legislature requires. So you cannot further restrict it. Allow that language, allow the legislature to say, that's not what we meant. We actually mean something similar to what this gentleman described, if you will. In other words, just to say, these are not inconsistent with each other. Put that language in the statute and you take away that argument.
Yeah, but on the other hand, they may change it totally and we'd be liable for whatever.
They may go completely against all the recommendations.
Well, is that really an issue that we need to address, in my opinion? That's contractual law that hasn't got anything to do
But at least we have
with our contract with our consumer, and nothing to do with the real estate commission. in my opinion.
Absolutely.
Yes.
So, well, just to.
I don't think we ought to be even discussing that personally.
Well, I mean,
But what's the harm with what Doug's talking about as far as making the recommendation to the Census Committee that inspectors are allowed to, limit the liability within contracts between inspector and client?
It's like what Steven said, though, they could disallow.
Because they could disallow.
Well, that's the whole reason why this is coming up, is because they're talking about
But it
this.
sounds like they already.
No, that's only the only people that are talking about it is staff here.
Right, I don't think they
It's
are
not coming
talking
from the
about it.
legislature.
Right.
That's coming from Deputy General Counsel and Counsel. Is that
What
correct?
you said that part of the Sunset Commission coming through was part of what they were referring to?
What we
Was-
said, what the commission asked for was for this body to consider all consumer recovery issues. And when you talk about consumer recovery issues, this factors into that, because if you have a contractual limit in your if you have a liability limit in your contract, then that, in many consumers' eyes, would suggest that there's no other remedy available to them. So if those consumers aren't aware of the requirement to maintain financial responsibility, and they aren't aware of the recovery fund, then they're uninformed, and they may believe that that's all they're entitled to. So what we wanted to do was to make you aware and make you discuss all of these issues so that we could get the clarification going forward. That's what we
Wasn't this brought up by
were
an
hoping.
inspector via email, some of this stuff?
It's brought up by Christian.
Well, I mean, when we started looking at all of these recovery fund issues, one of the inspectors at one of the meetings said, well, we have this contractual limitation of liability. And then staff, in looking at the insurance requirements, we found that some insurance agents were giving inspectors discounts on premiums for including those contractual liability limitations in their contracts with consumers. And we also found that out of all of the inspectors that we looked at, probably 90 to 99% of the inspector websites that we checked have those contract limitation clauses
Right.
in their contracts.
So without going off on too many other avenues here, I think everybody in the entire room is pretty much in agreement that we don't want to get rid of the ability for the inspector to have an agreement with their client. Am I correct in that?
Right.
Okay, so we're all on the same page. So how do we clarify this to move it forward to the Sunset Commission? So we're all trying to say the same thing. We all want the same thing. How do we clarify that move forward?
and that is the new question where there is disagreement, and some just say, let sleeping dogs lie. Don't address it at all, right? Because you might not like when you wake the dog up what happens, right?
Understand?
Other
Dog
than-
may bite.
And say, or to say, here's the issue, this is what is the practice out there, we don't have a problem with it, we just want to make sure that it's clear in the statute, because you, the legislature, created this financial responsibility requirement, and that's fine. We're okay with that. But we want to have this continued limitation of liability. We want the right to be able to continue to do that. Are you okay with that, too?
Well, our international.
Those are inconsistent.
Our
They're not
international attorney
inconsistent, so.
addressed that and said Texas law already allows for courts to nullify contractual provisions. And he wrote a little article here, but he gives you a couple of case histories on it.
The
That,
case histories are not entirely accurate, because his article relies on the head case that we've discussed at previous inspector committee meetings that was decided before the financial responsibility requirement was even put into the
This was
statute.
Phillip versus Phillips.
Well, the other cases he relies on are out-of-state cases, so they are not necessarily applicable, and a court may not follow them in Texas.
Well, he's got one in Texas with Ocean Foundation Company. I mean, he's got other cases there. It's not just that one. Have you read that?
Yes, I have read it, and I have looked at the cases. What I can tell you is that the Texas courts have said that limitation of liability clauses, they are enforceable so long as they are consistent with public policy. The public policy that you have is in the statute that requires you to maintain financial responsibility. So your limitation of liability is not consistent with that public policy statement.
I personally still think that should not be within TREC's preview. I think the contract ought to be totally outside of this.
Yes, sir.
And we are, and I think what we're saying here is not inconsistent with what you just said, which is we're not asking for the right to determine whether or not unilaterally this should be, how it should be decided, or whether you should be able to do that. I think what would be helpful is, rather than case by case by case, which is exactly what you read, that the courts, a court can do this, absolutely right. A whole lot easier if the legislature says, you know what, we've already spoken on this. An inspector may limit their liability. Then the court is now, they've taken the discretion away. They've clarified that for you. You don't have to go to you don't have to do court case after court case after court case with inconsistent results every time.
So basically, we have two options. We can not do anything, or we can specifically state in some way, shape, or form that it's okay for an inspector to have an agreement. But the risk, there's risks on both sides. The risk on the latter is that they go, wait a minute, this shouldn't be the case, and we bring something to their attention they never even considered in the first place, and then they kick it back out.
Right.
But I think if we do nothing and we let the sleeping dogs lie, as we were talking about, if at some point they're going to come through and try to push that through, and somebody gets a wild hair and says, hey, we need to do that, I mean, we can fight it then.
Well, from an inspector standpoint, from an association, I can tell you, whenever it comes up to going against the legislation, we still have such a small voice, Lee, it's not going to make much difference what we say. So, I'd leave it alone personally, and that's what our association desires to do.
That's what we're saying is maybe just don't do anything and leave it alone, and then wait and see if there's, if it comes up in a lawsuit with somebody, and then we.
Well, the only thing I would add to that is, because we're going through sunset, it will get looked at.
It will get looked at.
It'll get looked at. So I'm not I would rather you guys come up with a preferred solution as a recommendation, because it's gonna get looked at.
Do we have any historical example of how the legislature has looked on our recommendations or other sunset recommendations?
I would just say that every recommendation where and this is just in my history, this is only since 2009, okay? But everything we've taken to the legislature where both associations have been in agreement has passed. Everything that if one association didn't agree, was pulled. So when you speak with a united voice, actually stuff does get done.
Well, just
for clarification, since it's not written in anything in TREC, how would it get brought to their attention? The contractor.
Through the sunset.
But it's not anything to be reviewed.
Well, okay, let's look at another possibility here. It was brought up by staff.
Okay.
Sunset Commission's going to be interviewing staff and going through it. He's pretty much telling us it's going to come up. So
it's on the self-evaluation, guys.
That's correct. It's in our self-evaluation.
It's going to come up. So I think that's Doug's point, it's going to come up. You can either give them a definitive answer from your industry as a whole, and this is what you want, or you can say nothing and let them make up their own mind.
Why can't you ask for permission to leave the decisions in the courts where they currently are, since they can be decided on a case by case basis?
We should just
why not
allow an inspector to have agreements?
Well, the problem with this is that part in yellow up there, which is not negotiable. The way that's phrased on my contracts, where it says the amount of, excuse me, my name's William Riley, but I'm just here as a lone voice. Where it says limited to the amount of the fee on my contract, it's blank. We talk about it.
And that's
What are
as
you
a-
comfortable with? Because
And as a business owner, that's your absolute right to do.
Right.
But what we're not talking about that. We're talking about Trek's ability or the ability for you to even go into that contract and limit any type of liability, regardless of the amount. That's what we're talking about, not how much.
I
The dollar amount's
understand,
irrelevant.
I understand that, but what, I think that what I, in sitting through this meeting and in watching a couple of videos of these meetings over the last few months, what I come away from this with is the impression that consumer protection equals elimination of risk. And the problem that I see with some of the promulgated forms from the commission, notably REI 7-5, and all that language that's in REI 7-5 is delivered to consumers after they've signed the agreement and after you've performed the inspection. Then you tell them what all the limitations are on the inspection. Then you tell them you may not discover all defects. That's when we're telling, unless you have your clients read it before you enter into the agreement.
Preamble, right?
Yeah,
The preamble
preamble.
after you're done.
Unless you have them read that before they sign the agreement, they're agreeing to something that they've never actually seen the rules of. The same thing goes for the standards of practice. I don't know if anyone in this room furnishes their clients with a copy of the standards of practice, but I have made it my practice. And I always ask them, did you read it? And I have never once had a person say, yes, I read it. They say, I looked at it. Because it's unreadable to them.
Yes.
They
Well,
can't, so you're asking someone to sign a contract whose rules they cannot read, and you're telling them what the limitations are in the contract after you've done the inspection.
But they can't change the rules of the preamble.
Right, exactly. And so it's all backwards. And unless you front load the agreement, then you don't have a prayer with this in a court. Because that's exactly what they're going to do, is they're going to look at it and they're going to look at the sequence of this stuff and they're going to say, no, you're liable for this. I don't see an inconsistency between the requirement for financial liability. I have that. I meet that requirement, and it coexists just fine with this limitation on liability because I talk about it and I explain. Up front, I am going to miss things. There is no way that anyone in this room can go through a house and catch every defect. There's just no way. It's an impossible standard. And if you want me to take more time and find more defects, then it's going to cost you more money. So if you want my fee, say my fee is $500, well, I spent 7 hours on an inspection back in January, and I felt like I got about 50% of it covered. I'm not kidding you. It was a 45-year-old house that had more stuff than, I mean, I could have spent a week there. You know? Well, so I lost my train of thought on this, but
They can coexist, and they're two totally different things, in my opinion.
exactly. That's the way I see it. I meet the legislature's requirement is that I have this responsibility. They are silent on the issue of whether or not I can have this contract. It's tolerated in this state. Some states forbid it altogether, but they're silent on it. On this, they didn't say we can have it, but they also didn't say we can't have it.
And so they leave it to the court every single time, and you made a great argument for strengthening your position in court by making this less of a contract of adhesion, where you discussed those limitations before you just put them on notice later.
Exactly.
And that's a great professional practice. We're only, I think the discussion came down to exactly what you just said, is that the statute is silent on it. It doesn't say you can, doesn't say you can't, okay? Would the inspector's position be strengthened if it said you could? That's the question.
The inspector's position would certainly be strengthened if the legislature said that we could do this.
So
It-
that's where we
But
are.
that doesn't necessarily mean that when you get to court, it's still gonna hold up if you just do it like
Exactly.
this.
You're talking about step 7. We're
But
talking
you
about step
strengthen
okay.
the argument.
Okay.
In the same way that you just strengthened your particular.
I think if this were to pass the legislature, yes, I think that it would strengthen, I think it would strengthen the inspector's position.
I'd like to respond to his comment. Any agreement signed the day of the inspection, at the inspection, is considered putting that client under duress. That
Right.
agreement's null and void from the get-go.
That's not
All my agreements are
Well-
signed the day prior. You don't ever put the
Again,
client.
I can't speak to that.
I know.
Advice.
My recommendation is go ahead and give a recommendation.
You know, my first thought was to leave it alone, but I think Doug makes a good point that it's going to be looked at, and when Doug sits there and looks at me and tells me it's going to be looked at,
It's going to be.
it's going to be looked at. Been here long enough to know that's the way it's gonna work. So if we're gonna do it, I just assume we put, as a committee, we have a united front to make a recommendation that it be a continued practice to allow the client to have an agreement of liability or a limit of liability with their consumer.
Okay, so that's your motion?
That's my motion.
Second. All in agreement?
Any discussion?
Is this
One more discussion, sorry.
Is this just a suggestion as far as wording and verbiage?
This is not, this is
Example.
not a suggestion. This is just an example of.
Not verbiage, just to allow the inspector and the client to have a agreement of liability. That's it. Not wording, not dollar amounts, not nothing, just allowing the two parties to have a contract that limits their liability.
Realizing that the court can reverse either way it goes.
The courts can do all sorts of, if you've ever been through an eviction, you know it doesn't always go the way it's supposed to.
They can do whatever they want. They declare laws unconstitutional.
Okay, so is there any more discussion on this topic? No. Barbara?
Barbara?
One more time?
You agreed to request permission to do it?
Yes.
Okay. So, all in favor?
Clarification.
Aye.
What is the motion?
That we make a recommendation to go forward as part of this whole package to go to the IAC and to the commissioners, to the Sunset Commission, that it be permissible for the client and the inspector to have a separate agreement for limiting liability.
So add language to the statute that allows limited liability.
Specifically allows limits of liability within contracts between the inspector and client.
Okay.
So again, that's all those in favor. Were there any who abstained or were against that motion?
Hang on, you guys.
Okay.
What was that?
All opposed.
All opposed? Okay.
Does that mean the association probably won't? Are you representing Paul or the
I think
association?
the association will say no.
That they don't want to address it at all?
That the association.
Yeah, I think so.
Okay.
But most
I'm
of
a
them.
member and I would say I want clarification
Okay. To Priya.
of this. I don't think that if it's gonna show up anyway, and you're sitting here as telling me that and you know that's gonna happen, only thing I can do is trust in your information, then I would much rather have clarification on it than give them free rein to do whatever they want.
Absolutely. That's the intent.
And if that's against Priya and Internachi, then I'm sorry, but that's how I feel as a business owner.
Because if it comes up to them and they don't have a recommendation, they will do
Whatever they think, and that may be
Without
something
even-
based on something not inclusive of our
And you don't
industry
think
at
they
all.
are anyway?
No, because that's what Doug was just
What
saying.
comes
He's saying
to
if we stand united as the industry as a whole, they generally back us.
Correct.
Currently, staff is, and I'm going to say something that you may not feel comfortable with, but our Deputy
Okay,
General Counsel supports not having a limitation of liability in our contract.
I don't think so. She's never said that one way or the other.
Well,
I
she's
think what
implied
she's
that.
asked is for clarification.
She's implied that it's in conflict, so.
I don't feel that.
She didn't
I
imply
thought
it,
she was
just
making us
stated.
aware that there could be an issue with it.
She just stated there's a conflict.
I just said that there's a conflict. I
Right.
didn't say
Give
anything
her personal opinion on
Where
with
it should
respect
come
to
down.
whether or not you should or shouldn't have one. I mean, that's for y'all to decide.
Steve, next time you guys have to switch seats.
It's okay, Brad.
Okay, so now we're on
We
agenda
can.
item 3, which is discussion of future meeting dates. We already have a meeting set for April 9th for a full IAC committee meeting at 10 a.m. here. I don't know if we have any SOP
I think the
or
intent was to see if
subcommittee
there was a need for a future meeting date.
on this. Well, I'm just letting you know that if we want to do anything within the next 2 weeks before the next full inspector committee meeting, that would have to be the time for any.
I don't see any need for that.
And so we're done with this.
Is the survey still going out?
Yes.
No.
Everybody's welcome to attend any of the inspector committee meetings. And they're
Well,
all
I
posted.
hadn't heard for sure.
And now we're doing teleconference, or video streaming, aren't we?
Sunday.
Streaming,
doing
we're
the
doing
streaming at the main
streaming.
meeting?
Yeah, we're streaming.
April or May?
Good day.
April.
April the 9th.
All the main meetings, all the full items.
Are you looking
I think we're-
at the media source where you're able to interact?
Haven't we got the streaming up now?
It's observation, it's not interactive.
Right.
Yeah.
You have to do
It's just to watch.
go-to meeting.
But it is streaming, so they
Right,
can.
it is.
We
They
we
can-
tested one and we have the capability to continue.
Okay, because somebody's gonna bail me out of town. It is 12.
In this room, in this,
She's got plenty of time.
Subject to change, okay? We're actually trying to get, we actually had someone come in and provide that service that first time. It was part of a test. So we're attempting to get the right connection for our camera to be able to do that. So I can't tell you for guaranteed that it's gonna be straight, okay?
Okay.
We have that downstairs, do we not, Doug?
We do downstairs. I don't know that we have the room available.
But it's possible to get
It
the
is
room.
possible, but we have to get the company that does that, who controls all that equipment to come in and do it.
Okay.
And it'll cost us a couple grand to do that.
So let's just.
Pull it out of
Let's
the recovery fund. Sorry, I haven't done that one that out loud.
You need to have some more cameras.
Unfortunately, you can't do that. I'd like to extend an invitation on April the 2nd to the single-family residential summit that we do. It's going to be at the Austin Board of Realtors, and it is all about both valuation and conditions effect on the market of major disasters. So obviously we've had several. We had floods and fires, and of course Hurricane Harvey is enormous. But are there, so we're looking at the implications of that on the real estate market and its timing recovery and all that. And we have inspectors on the panel as well. Fred Wilcox is going to be on the panel to talk about, post-disaster inspection considerations. You will get continuing education credit if you come. It's really inexpensive. If you stay for the whole day, it's 5 hours for $35. And that includes lunch.
And you still have your strategic planning sessions coming around the state too, right?
I have we have tomorrow afternoon is a live one, town hall, and then Wednesday is in El Paso, and that's the last one. That's the last one.
Tony was going to
Or
send me
Thursday.
an email on that.
One of them.
Second
One of these days, sorry.
it's on the website?
Facebook
It's on the
Live, is
Trek
that
website?
the live one
Tomorrow.
is the Facebook Live,
Facebook
right?
Live tomorrow.
Okay.
If you want to interact, and then I think Wednesday is El Paso, and I think that's the last one for the month,
I don't have a-
for the series.
First thing.
When was the other meeting? Disaster.
Well, that's April the 2nd
Got the
at the
address
Austin
and
Board of Realtors
You have
here
to
in Austin.
register.
Yeah.
Will there be any kind of word on the
So you click
website?
on
What time?
register
It is
page.
on the website already,
Oh, okay.
and you can sign up there, and it is, it goes from
Tony sent
10
me a
to
note
3,
about it.
5 hours, 10 to 3.
Week from today.
Huh?
Week from today, right?
Is it a week from today?
Is it?
Yes.
Yes, it
Monday,
is.
April
Yes, it
2nd. There you go, week from today.
All runs together, then.
March is done.
The day after Easter.
Yeah.
Celebrate Easter.
Easter Monday.
2 days after Passover.
Easter is April Fool's Day.
All right, it is 12:11, and we are going to adjourn this meeting. I appreciate everybody's input and everybody coming. It's really helpful for us.